ಇವ್ರು ಹೈರಿಂಗ್ ಮಾಡಿದ್ರೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಸಿಸ್ ಮೇಲೆ ಬಂದಿದೆ.
ಮಾಡ್ಕೊಟ್ಟಿದ್ರು ಸರ್ ಬರೆದು ಕೊಟ್ಬಿಡ್ತೀರ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀವಿ ನಿನ್ನೆ ಅದನ್ನ ನೋಡ್ರಿ ಅಂತ. ನಾಳೆಗೆ ಹಾಕ್ಬಿಡ್ತೀವಿ ತಗೊಳ್ಳಿ. ಸರ್ ಅದೇ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ನೀವೇ ಬಂದು ಸಾಹೇಬ್ರ ಹತ್ರ ಹೇಳ್ಬಿಡ್ರಿ ಅಂತ. ಅಲ್ಲ ನಿನ್ ನಾವು ಸಬ್ಮಿಟೆಡ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದೀವಿ, ಅವ್ರು ಯಾಕೆ ಮಾಡಿ ಯಾರಂತ ಏನಂತ ಏನ್ ಸ್ಟೇಜ್ ಇದೆ ಅಂತಂದ್ರು ಪೋಸ್ಟ್ ಮಾಡು ಅಂತ ಹೇಳ್ಯಾರ. ಇಲ್ಲ ಅಂತಾನೆ ಅಂದ್ರೆ ಆ ಮೆಮೊ ಬಗ್ಗೆ ನೀವು ಬಂದು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ರಿ ಸಾಹೇಬ್ರಿಗೆ ಅಂತ ಹೇಳಿ. ನಿನ್ನೆ ಅದನ್ನ ಏನಾಗಿದೆ ನೋಡು ಅಂತ ಹೇಳಿದ್ರು ಅವರು. ಸರ್ ಕೊಟ್ಟಾಕೋದಿಲ್ಲ.
Number 30, I request your lordship will be taken on 21st. Yesterday I was in the hospital for some, I have not gone.
Blood. One submission. I am for respondent in that. Because of the change of the AGS, I am having no objection. Change of the AGS. My beloved AGS sitting other side was all along. Now that he changed, he only shall appear next date. That is my submission. My lord may grant adjournment. I have no objection. I have no objection. Only he should argue, no, not that other advocate. Other advocate, I have objection. My lord will serve the pardon order sheet dated 5th September. If the other side, other AG makes, I have objection. If he makes objection, I have no objection.
There is no divorce ಅಲ್ಲಿ ಅವರಿಬ್ರು ಜೊತೆಲಿದ್ದಾರೆ. They can't be separated also.
ಹೌದು.
ಇವರಿಗಾದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ, ಅವರಾದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತೀನಿ ನಾನು.
ಆಯ್ತಾಯ್ತು, ನೋಡೋಣ. I'll fix a date. ನಮಗೆ ಫಸ್ಟ್ ಅಲ್ವಾ?
ಹೌದು.
So we are seeking adjournment. We'll have
21st.
Relist on
16, 15, 16, my lord.
15 ಬೇಡ.
17.
17.
Yes, yes. If my lord permits me, his name may be written in the orders.
Not necessary.
They are one inseparable.
ಯಾಕಂದ್ರೆ 2022 ಅವರೇ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇವತ್ತು ಹೊಸ ಮುಖ ಬಂತು. ಐ ಆಮ್ ಹ್ಯಾಪಿ. ಐ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್. ಲೆಟ್ ದ 17 ಲೆಟ್ ದೇರ್ ಬಿ ನೋ ಚೇಂಜ್ ಆಫ್ ಫೇಸ್.
ಅಲ್ಲಲ್ಲ, ಅದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದು. ನೋಡೋಣ.
ಗ್ರೇಟ್ಫುಲ್.
ಅವ್ರು ಅಷ್ಟು ಒಳಗಡೆ ಅವ್ರ ಮನಸ್ಸು ಚೇಂಜ್ ಆಗ್ಬೇಕು. Yes, next.
A week's time finally.
Week's time granted for necessary compliance.
Week's time. A week's time.
Week's time granted finally. ಎರಡು ಡೇಟ್ ಕೊಡಿ.
Week's time.
Week's time granted to do the needful. Yes.
Filed an application for dispensation of notice to R6 notes.
Week's dispensation
Yes, my lords.
in a suit.
In an appeal, notes, I filed an appropriate application
Correct, but how you can seek dispensation?
because R6 was placed ex parte before the trial court.
No, that's okay. We don't know how we are going to decide. You better
Since it
take
was only objected by R7 notes,
No, that's okay, but let us
Yes.
see, because we are deciding the appeal. We may
Yes.
decide either way, may have some implication. You take out substituted service. Third time ಆಗಿದೆಯಲ್ವಾ, ಮತ್ತೆ
ಇಲ್ಲ, ಈ ಸರಿ third time,
take out and next time substitute service.
please.
Sixth time granted to take necessary steps for R6.
Application pending ಇದೆ ಅದು.
Huh?
Application is pending. I had filed an application. If that is disposed of, I'll file another application for.
Which application?
Application notes for dispensation of notice to R6.
ಬೇಡ. IA for dispensation stated to have been filed is kept in abeyance for the present.
Bless.
Suppose you withdraw it, let us see, you withdraw it. We are not inclined to dispense with notice.
The reason being notes, is placed
Maybe,
ex parte.
but it's an appeal. Though learned counsel for the appellant submits IA has been filed seeking dispensation of notice to R6. However, taking note the nature of the present proceedings, it would be appropriate that steps are taken for service as regards R6. Accordingly, issue notice to R6.
Bless.
Yes.
Bless.
ಕೊಡಿ, ಯಾವಾಗ ಸತ್ತೋಗಿರೋದು? ಯಾವಾಗ ಸತ್ತೋಗಿರೋದು? Abatement is 60 days or 90 days? Abatement.
Abatement, my lord, 150 days,
Huh?
150,
90 days.
total 150.
90,
First 90, then 60.
90 days.
90 first, my lord, thereafter 60 days.
Huh?
90 days, my lord, first 90 days, thereafter 60 days. Total is, my lord, 150. Abatement.
Narendra, ready.
I appear for the
Huh?
respondent.
Abate agalwa ಇದು?
60 days.
5 ನಿಮ್ದೆ ತಾನೆ?
Yes, ma'am.
ಹಾ.
The appeal, my lords, was filed by the father and son relationship, my lords. Father has now expired, my lords. So the appeal has to be abated, my lords.
ಹಾ.
Because I alone will be the legal representative of my father.
ಹ್ಮ್.
So the appeal has to be abated.
You file it? ಹಾ. So we'll close it.
Yes, my lords.
What was the suit filed? Huh?
Suit for declaration was filed
For?
between father and son, my lords. Suit was between father and son.
Haji. Correct, but then what happened to the finally to the suit? Suit was
My lords, suit was, my lords,
dismissed.
dismissed. Appeal was filed, my lords, stating that, my lords,
We'll only say abate.
please, my lords. Because it was father's property, my lords, I was claiming as a,
Correct, but then
Yes.
what happens to the rights already decided?
no, my lords, since if even if the property is declared to be as self-acquired property of the father, my lords, as per section 8, my lords, it will devolve upon the legal representatives.
You want to file a memo?
Memo, my lords, I don't have any further instructions from the party to file a memo, my lords.
Okay, what you could say
Yes, my lords,
that contentions may be kept kept open
please, my lords,
and it may be disposed of,
please.
noting that he is the only legal heir.
My lords, only legal here in the sense, my lords, if I don't have any instructions regarding if any other legal heirs are also there, my lords, like in the sisters, my lords, of the party. So, my lords, all contentions can be kept open and the appeal may be abated, my lords.
It is submitted that the respondent, sole respondent has died and the appellant is the son.
Please.
As no further, in light of said facts and no further steps are taken, appeal stands abated.
Please.
However, contentions are kept open.
Please, my lords. Oblige, my lords.
Yes, please.
Appearing for the appellate. In the other connected matter, office objection has been kept an abeyance and interim order may same order. And it has to be listed on 22nd.
Name order list along with MFA number 202762 of 2022 on
Second,
22nd.
respond number 3 is the government formal part.
AGA accepts notice for R3.
R3.
Then the others,
Please, ma'am.
other respondents,
Others are the private party notice has to.
issue notice to respondent 1 and 2.
Please.
Yes, next.
7, my lord, I will take notice for responder 1, my lord.
AGA accepts notice for the first respondent. Now, what is the matter?
Or this is, my lord, trying to see page number 14, my lord. The learned single judge directed the, my lord, Tahsildar to consider the representation annexure D and F.
Madidira?
That is, my lord, kindly see, my lord, that order was, my lord, 9/9/1997. That was, my lord, matter is remitted to the my lord, tribunal. But tribunal now, there was no members to the constituted to the tribunal, my lord. For that is a reason not commenced. Thereafter, my lord, we appointed the my lord members that tribunal is commenced, my lord, from 24/12/2024. Date is given, my lord, 3/1/2000. Kindly.
The delay in filing contempt,
Pardon, my lord.
there is a delay in filing contempt.
Yes, my lord, that is there is a delay, my lord.
Hmm?
Order is passed, my lord, on 22, my lord, 8/6/2022. Complaint is filed on 13/10/2023, after lapse of 1 year.
1 year.
Yes.
What is the order of the DC?
Order of the DC, my lord, that is, he is not produced, my lord,
Not produced.
not produced.
What was the direction?
Now, the directed the tribunal to hold the inquiry
That's all.
regarding the dispute regarding the matter is pending before the tribunal, my lord. Tribunal is, my lord, now constituted, he proceeded the inquiry,
So the order of the DC
Please.
is subject matter before the tribunal.
tribunal, my lord.
Huh?
Yes, my lord.
That is yours.
Yes, my lord. That's why, my lord, I filed the memo also, my
You
lord.
cannot consider those representations.
Unless taking the decision by the tribunal, we cannot enter the name.
Huh.
That is the memo, my lord, I filed it.
Petitioner is complaint, petitioner is. Petitioner advocate. Pass over.
Please.
ಬಂದು ಸ್ವಲ್ಪ ಕರೆಸಿ.
This will be taken next week, my lord. Next week. They have submitted yesterday, almost 400 matters have been disposed of. We will verify, my lord, anyhow, and I have the instructions. It will be taken on next week.
Monday.
Monday, Madam Swami, ಅದು ಹಬ್ಬ ಇದೆ 16th,
16.
please,
Relist on 16. You tell us what is the position.
please, my lord.
It has to be.
Yesterday, his lordship said one judgment, 2024 online SEC online 513,
Look into
Kotta
it.
party. It is of old act, my lord. I have gone through it. ಹೌದು, ಅದು ಓಲ್ಡ್ ಆಕ್ಟ್ ಮೇಲೆ ಲಿಮಿಟೇಷನ್ ಇದೆ, ಇದು ನ್ಯೂ ಆಕ್ಟ್ ಇದೆ.
Then this has to go, it has to go.
Please,
Take it.
please, my lord, 16th.
Learned, the Solicitor General may be directed to take notice. He is already appearing for 3 and
Take
4.
notice, my lordship. Kindly peruse the page number 78, my lordship. Page number 78.
CSGI accepts notice for respondent 1 and 2,
1 and 2.
All respondent.
for all the respondents.
Page 70, impugn order, page 78, my lordship.
Page
78. Para 8. That apart, it is not disputed that applicant has not preferred any statutory appeal against the denial of disability pension to him as provided by law before approaching this tribunal. According to section 21 of the Armed Forces Tribunal Act, the tribunal shall not ordinarily admit an application unless it is satisfied that the applicant has availed of all the remedies available to him under the Arms Act 1950. So this petition also not maintainable, merge. The statutory appeal before the statutory authority, merge. Regarding the pension.
Why don't you go before the Armed Forces Tribunal?
Not go.
Huh?
Tomorrow it may be called. I will submit. I thought it is for orders. Tomorrow it may be called. I will submit.
No, we'll have it tomorrow. Examine that. If there is a bar and.
Appeal remedies are not availed. Appeal remedies are not availed.
Saying that there's a bar, examine that position. Then we'll keep open contention, you can,
Yes.
we'll have it tomorrow. Huh? No, other,
Pass over what, just go through the 21. Appropriate would be, will give
Hey,
liberty.
if Lord giving liberty, my Lord may dispose it off. Giving a liberty to approach appellate authority, my Lord may dispose it off.
delay.
ಅಲ್ಲಿ ಇದು ಲಿಬರ್ಟಿ ಅಂತ
Please.
because there is no adjudication on merits.
Followed. Insofar as the limitation is concerned, kindly make an observation.
The present petition has been filed in setting aside of the order passed by the Armed Forces Tribunal Regional Bench at Annexure C. The appeal was filed before the Armed Forces Tribunal, aggrieved by denial of disability pension to the applicant. They said the application, appeal and application came to be dismissed, observing that the remedy under Section 21 of the Armed Forces Tribunal Act was not exhausted. And in the absence of appeal provided for under the statute, the original application was not maintainable. In light of such facts as made out, including the legal position enumerated at para 8 of the impugned order, the petition is disposed of, reserving liberty to the petitioner to avail of statutory remedy as is permissible in law. Time spent before this court is to be taken note of while considering question of limitation, if any.
Delay.
Contentions are kept open. Full stop. If appeal is filed, authority may take note of the proceedings having been initiated before this court in an appropriate manner, considering the grievance relates to disability pension.
Within 1 month, if I approach, delay shall not be raised. Great.
Yes, disposed of. Yes. Review petition ನೋಡಿದ್ರಾ ಅದೇನು?
Yes, yes, third copy of one.
Committee secretary is presented, my lord. before this.
Yes.
Sorry. The third copy, my lord, there is no such
ಅಲ್ಲ, review ಏನು?
review petition, the third copy of the order.
Huh?
Yes.
What is that? What is the order passed?
My lord, they have made a submission that they have submit that response should not permitted to pick and choose the particular site for allotment. The court observed that do not find any such directions given by this court in so and so. Our order dated so and so. We have directed the state and the supermarket to allot sites measuring 20 into 40 square feet in supermarket to respondents. Therefore, it is dismissed.
Para 5 months.
By earlier, my lord, by considering their affidavit only, the writ appeal and contempt were disposed of. The writ appeal is dismissed.
Page number 9, madam, para number 5. It's a relevant para.
Yes. Just now I read it, para 5.
So then you have to seek for Against this order, you have to seek clarification, another.
Yes, my lord, they have to, by my contention is, my lord, by going through these pleadings, my lord, when they have filed the affidavit along with these proceedings, for a moment, my lord, may I have brought to
You
the,
are correct, we are with you.
Yes.
On that matter was disposed of on the basis of the stand taken.
if,
by-
if they have issued notices, may I would have brought to the notice of their court in the same manner.
So then you seek for some, it may take some time, but the only way out for you is to seek some relief in this procedure.
ಅಲ್ಲ, ಈ ಕಂಟೆಂಪ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ when they have filed the affidavit.
ಇವಾಗ ಅದೇ ಲೇಔಟ್ ಅಲ್ಲಿ ಬೇರೆ ಸೈಟ್ ಆಗಲ್ವಾ?
ಇಲ್ಲ, ಅದರಲ್ಲಿ that they have asked me, for a moment, you asked me kindly see the affidavit where they have conducted proceedings and furnished the details of the sites.
Correct. What we are asking, now suppose in that same block,
ಸೇಮ್ ಬ್ಲಾಕ್ ಇಲ್ಲ, ಅವ್ರು 31, 32 ಅಂತ ಹೇಳ್ತಾರೆ ಇದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ. ಆ 31, 32 ಅವ್ರು ಸ್ಕ್ರಾಚ್ ಮಾಡಿದ್ದಾರೆ ಬಿಕಾಸ್ ದೇರ್ ಇಸ್ ಸಮ್ ಲಿಟಿಗೇಷನ್ ಅಂತ. ಇವ್ರು ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಪೇಜ್ ಮೈ ಲಾರ್ಡ್, ಲಾಸ್ಟ್ ಪೇಜ್ 31, 32 and 14 sites proceedings along with the list of their sites which are available in the supermarket area. In phase 56, 55 is the proceedings, my lord. R1 along with their affidavit they have filed the proceedings.
no, now where they are giving, now which site they are giving?
Site 376, 377 that is available, man. Next 31, 32 that is litigation anta avare scratch ಮಾಡಿದ್ರು ಅದರಲ್ಲಿ. Last may kindly see the ink page 55 in 178, my lord. One 178, 200-178, 200-178, my lords.
ಎಲ್ಲಿ?
55. R1. Last 200-178 contempt ನಲ್ಲಿ they have furnished. That is different. 178.
179.
Yes, 178, my lords.
Eight.
Yes. Ink phase 55, that is a proceedings, my lord, along with their affidavit. That is annexure R1.
ಸಭೆ
ನಡವಳಿಕೆ.
ನಡವಳಿಕೆಗಳು.
Yes, my lords.
ಹಾ.
First, Kalaburagi, first paraದಿಂದ. Kalaburagi, may I read it, my lord?
Yes.
ಕಲಬುರಗಿ ಫಸ್ಟ್ ಪ್ಯಾರಾ, my lord. ಕಲಬುರಗಿ ನಗರದ ಸೂಪರ್ ಮಾರ್ಕೆಟ್ ಪ್ರದೇಶದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಕಲಬುರಗಿಯವರ ಆದೇಶದಂತೆ ಸೊ ಹಂಚಿಕೆ ಮಾಡಲು ದಿನಾಂಕ 2/2/23 ಆದೇಶ ಮಾಡಿರುತ್ತಾರೆ. ಖಾಲಿ ನಿವೇಶಗಳನ್ನು ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಹರಾಜಿನಲ್ಲಿ ಮುಖಾಂತರ ಹಂಚಿಕೆಯಾದ 263 20/40 264 ಅಳತೆಗಾಗಿ ಬದಲಾಗಿ ನಿವೇಶನ 376 ಅಳತೆ 30-40 ಮತ್ತು ನಿವೇಶನಕ್ಕೆ 370 ಅಳತೆಗಳಾದ 30-40 ಅಳತೆಗಳ ನಿವೇಶನಗಳನ್ನು ಸಂಖ್ಯೆ ಹಂಚಿಕೆ ಮಾಡಿ ವ್ಯತ್ಯಾಸ ಮೊತ್ತವನ್ನು ಪಡೆದು ಬದಲಿ ನಿವೇಶನಗಳನ್ನು ಹಂಚಿಕೆ ನೀಡುವ ಕುರಿತು ಚರ್ಚಿಸಲಾಯಿತು. ಈ ವಿಷಯ ಕುರಿತು ಸದರಿ ಬದಲಿ ನಿವೇಶನ ನಿಯಮಾನುಸಾರ ಮರು ಹಂಚಿಕೆ ಮಾಡಲು ಸದಸ್ಯರನ್ನ ಕಾರ್ಯದರ್ಶಿ ಅವರ ಅಧ್ಯಕ್ಷ ಗಮನಕ್ಕೆ ಸಭೆಯಲ್ಲಿ ತರಲಾಯಿತು. ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು so without taking your time, my lord, they have furnished the list along with these proceedings. That is particularly in ink page 59. These are the 57 to 59 is the list of the sites available in the supermarket area. The list number, now they have making such a filing affidavit further, my lord. 31, 32, 14. The serial number 28, 29, 30. Now they are making, suggesting them to again they are allotting back earlier as per this proceeding. These 31, 32, 14 are, they are scratched because they are the civil litigations are pending.
As on date.
Yes, my lords. Therefore, my lord, again they have R3 as per annexure R3. R4, my lord, issued notices for the petitioners to pay the excess amount as per the market value. Therefore, this honorable court, by taking consideration of the auction dated that 12 so and so 88, no, there no need to pay the excess amount. When they have paid the entire amount in the year 88, you have to allot the 20/40 as per their so and so on. That is the intention to pass. The writ appeal was dismissed and in the made observation.
No, correct. So now, what are the site they're offering?
Now the R6, my lord, they have, last me kindly see ink page 66. Notice on me. R6, my lord, ink page 66. Commissioner Urban Development Authority has written letter to the executive engineer PWD. Sanction for amalgamation cum subdivision of plots under section 17(2) of Karnataka Crown and Country Planning Act. This is so and so, not 377 and 376. They already amalgamated and sites were marketed. After these, all these completion of proceedings, they have filed writ appeal. By considering these proceedings, my lord, writ appeal was dismissed again without notices. It was not brought to the notice of this honorable court. These proceedings was not brought because since we are not party, they were not issued notices.
No, that there is 377 and 376, they promised to give you earlier,
Yes, my lord.
earlier.
Earlier, man. Earlier, the first 88, it was cancelled. So the different sites were allotted, auctioned. Later on, when they filed the,
Hello,
Can-
what has happened to that 377 and 376?
that is vacant, my lord. Those plots are vacant.
They are situated on the main road in the prime place of the supermarket area. The area is very big, my lord. Earlier sites, my lord, which were auctioned in 88, 89, were situated by the side of the fort. Therefore, Archaeological India, they have objected, and now, my lord, subsequently, these people decided to.
No, but
You-
now you may have to seek for clarification in the review process.
ಅಲ್ಲ ಅದರಲ್ಲಿ 60/90 ಇದೆ ಅದು ಬಿಗ್ ಸೈಟ್ ಅಲ್ಲಿ ನಮ್ಗಿಂತ ಬಿಗ್ ಇದೆ ಇವಾಗ ಆಫರ್ ಮಾಡ್ತಾರೆ ಜಸ್ಟ್ ನಾವು ದೇ ಅವೇನ್ ದೇ ಫೈಲ್ಡ್ ಒನ್ ಮೋರ್ ಮೆಮೋ ಆ 31, 32 ಇದೆ ಅಲ್ಲ ಅದು 60/90 ಇದೆ ಅದು ದೇರ್ ಇಸ್ ನೋ accessibility. Therefore they are making such a.
No, correct, but now if there are other
No, my request is once they have filed the affidavit, they can't go beyond that.
let's have a
That
look
is
at-
again that amounts to contempt.
let's have a look at that affidavit.
Yes, which earlier, madam?
Yes.
Yes, madam. Affidavit in page number 50, my lords. Page 51, my lords, para 3. May I read it from para 3, my?
Let us have a look at the affidavit.
Yes, my lord. Ink phase 50 is the affidavit.
50.
Yes, my lord, 50. And 51 is from the para 4, my lord, ink phase 51, 51.
Which paragraph of the
And
affidavit?
the in paragraph from 4, my lords. It is, may I read it? Para 4.
Yes.
It is relevant to submit here that as per direction of the learned single judge, the respondent authorities come to with a proposal to allot alternative sites available in supermarket. The list of sites which were also available are produced here with. Just now your lordship gone through that list of that available, they have produced this one. And it is submitted that the submission was made if the alternative site is given, the difference amount has to be payable by the complainant. The said submission was accepted and granted time to execute necessary documents. It is submitted that the complaint number 1A given a representation and told to 20 requesting the respondent to allot 376 30/40 and Ramanadas also given representation for 376 measuring 30/40. It is submitted that committee conducted meeting on 18/11/23 and taken a decision the portion of 376 measure 20/40. Para 7, my lord.
Correct. Now there's only one technical hitch
Yes.
for you. In light of the observation made in the review petition, you may have to seek for clarification or appropriate relief. We leave it to you. Because of that observation made, that may come in the way of
Oh,
you.
correct.
Because,
Yes,
So that
in
you
the contempt proceedings, it may have.
so that you see what is to be done. We'll adjourn it. You decide what is to be done with respect to the review order. And then we'll see. Unless you are ready for any other site. Any other site in the vicinity, if you are, we can ask. But if you want.
This
real-
particular 376 and 337,
then you
we
may
have to
seek for some-
seek some clarification in this regard.
In connected matter, there is no review petition. And It is their notice given to me, my lord, saying that we'll be allotting in 356, 57, 58, and 50. It is their own notice served to me
Will
for
come,
my client.
just wait.
We'll seek
Sorry.
modification, there's some clarification of the review petition since they have not heard at the time of filing. There is no such clarity in the so and so. I will,
No, but you should have mentioned how you can get an order without hearing the other.
No, my lord, we at that time during of the hearing of this honorable court, my lord, we have brought to the notice of the court, my lord, some other claimants also, they are claiming
No,
the
correct, sir.
specific,
Correct,
I
sir.
agreed,
Without
my
hearing-
lord.
Without hearing them, how we can pass
Ma-
an order adverse to them?
That is a reason, and after the dimensions noticed by the deputy
us-
commissioner, we have brought to the notice saying that they should not be pick and choose.
Which is
that's
your
for
petition?
instruction, my lord, there is civil litigation. Civil litigation is there at 31, 32, and 14.
Let us see. Now, which is your petition now?
178, 179.
200, 178, 179.
Please,
That
my
will
lord.
adjourn for the present.
1 week, my lord. adjournment.
10.1, 10.2.
10.1,
10.2.
10.1 and 10.2 is adjourned at request made on behalf of the petitioner. I will not mention anything more. Will you?
Please, my lord, please.
Now, which is the other matter now?
Yes.
It's 200,165,
200?
165.
Put it.
There is no review petition.
65.
Delinked and adjourned.
The appeal was filed and that got
Delinked and
dismissed.
adjourned. Delinked and adjourned. Now, yours is?
Mine is 200,165 of 24.
So now,
I have only one copy.
Fine, very
I'll
well.
furnish it again.
objection only. I've delinked and adjourned. Yes. Put it.
That copy is served upon, there are totally 7 plots, Millets.
Yes.
So the connected matter was about 2 plots. Only in that case, they had filed writ appeal, review petition, SLP. These are all the connected other 5 remaining plots, Millets. And there, Millets, they issue a notice in 23, and the matter was pending there before the learned single judge saying that you come and you should pay whatever the excess amount is there. We are ready to allot those plots in 365, 367, 140.
Ready to take it.
But now they are denying it but they have not outrightly said that they are not going to allot it. But this is exactly what is said to me in the notice minutes.
Correct, but the 23, what do you say regarding?
My lord, stand up this case, my lord, actually, since the Supreme Court is dismissed in some other case, my lord, we have taken in the different manner, my lord, we are preparing to be as per the instruction for the SLP. Some accommodations as well.
SLP against which order?
Yes, yes.
Against the earlier one.
Earlier,
that is
not
what-
at this,
Yeah.
not on this case.
10.1, 10.2,
Only.
my lord, that against that, my lord, we filed the SLP before the court. That was dismissed on 2/1/2025. This is, my lord, the contempt against the learned single judge order, my lord, they filed. We filed the writ appeal before this, that writ appeal is dismissed recently. We
Against that, we
getting
need
that
to
order,
be
and we
prepared
take
to-
decision.
Cannot file.
That is dismissed.
They are all
on-
connected. This is in
Just-
respect of,
Just Supreme Court has held recently that if it's identical, then even without the litigant approaching the court, same benefit must be given. So how you can? Isn't
That,
it?
my lord, that we have to place all the, before the government, my lord, to take decision.
Government will take government has to be take a decisions, my lord. As per the instruction, the preparing for the SLP.
SLP
But
got-
the observation of this honorable court, my lord, we will communicate to them and we'll,
No, I'll have it next week. You decide and you take it.
yeah, please, ma'am. 2 weeks.
in
ma'am.
the interest of both the parties, Millets, let them serve a notice upon the agreed parties so that they can pass a fresh resolution in consultation with them. That will end the matter. Otherwise, since so many years, it is
I'll fix a date. You resolve it how you want to resolve. But there's no point. Then if you go to Supreme Court, what will happen? Same order will be.
Please. We also communicate, we all,
List, date code, 10 days admin date.
the order sheet of the last occasion also may be seen. That is what has been observed, Millets. The order sheet, previous dates order sheet.
Madam,
Now you take your stand by the next date.
Please.
No point in prolonging it any further. You just instruct them appropriately, give a cite and wash your hands up. There's no other way. You communicate to your officers who are present that you have to comply with it. Made clear
So,
that no
the
further time will be
committee
given.
secretary is before this honorable
No
court, my
further
lord.
time will be given.
He presence may be.
Compliance. Full stop. I can make an observation that benefit. Now you anyhow that order in SLP is there. Don't waste state resources in filing another SLP. You communicate to him, there has to be compliance. That you call them and tell them this site is there, this site is there, and close it. You are ready to take that in the vicinity.
The same, the notice which has been served, we are ready, my lords. I have already given the consent, but they are stalling because of the pendency of the SLP they had stalled. What they had said in the notice they have given, there are 5 plots available, we'll allot it.
You look into it, you issue a notice, call them and
Yes,
sort
my
it.
lords. That would be,
List the matter on date. Good.
the secretary is already present before the court. Anyway, the
22, 23.
20th. Who's the
2 weeks
secretary?
time.
secretary is already.
Secretary of the committee, my lord.
No, you tell him there's no purpose in filing an SLP. Again, same order will be passed. Absolutely no grounds to
My
pass
lord,
a
if,
different. Ground.
it is only the observation. It should not be in the order, my lord. If it is,
That's why I'm saying.
yes, yes. Please, my lord.
Communicate.
Yeah, we will communicate. My lordship is order, the impact, my lordship is aware.
Correct. So you communicate to him, there has to be compliance. Now you call them and you convince them that these are the places, allow them to do a spot inspection. And you also be
The
reasonable.
procedures, my lord, I will take a lordship with the 1 minute time. Procedures, my lord, this, the committee has to be constitute. For that, the committee members has to be intimate 14 days time advance. And thereafter, the committee is going to be conducting the meeting. Thereafter, this, the issue is going to be taken up as the directions of this honorable court. Thereafter, my lord, this, the property what belongs to all the site is required to be amalgamated because the KDA.
So what we are saying, you file an affidavit on the next date. That's why we are giving you time. Stating this is the procedure, this is how we are going to ensure compliance. Let it be on record.
Also private and
List on
22nd.
date.
22nd, you will also. 22nd.
Huh?
22nd.
22nd. I'm making it clear that you must file an affidavit
file
on that date. According to you, what is the procedure to be followed? How we are going to do the allotment? Yes.
Waiting for complainant.
Yes.
Is complied with. Copy. Page number 9, my lord. There is a direction, my lord. Consider the representation of the petitioner. That is considered and
Yes.
there is a direction, my lord, to consider the representation of the complainant. But in the representation, what he sought, my lord, from 1994 to 98, benefits has to be given to him. That is considered by the authorities, my lord, annexure R4. In my update, my lord, I filed on 6/6/2025, my lord. Page number 17, my lord. His request is rejected.
Yes.
Just, I have received my copy, my lord.
No, correct. Now they have. in
Yes,
terms-
yes.
So that you are liberty for you to. challenge.
Liberty may be reserved, my lord, to challenge the senders.
Hmm.
Take notice for all the respondents, my lord. We will not-
AGA. GA accepts notice for the respondents. The petition is filed complaining of disobedience of the direction WP 2000543 of 2022, wherein the court had directed consideration of representations of the petitioner. Affidavit is filed by the block education officer along with the annexure
Annexure R4.
R4. It is submitted that the representation has been considered. Full stop. In light of a refusal, in light of the consideration at annexure R4, which petty complainant says he is aggrieved by, liberty is reserved to the complaint to challenge R4 in accordance with law. Proceedings are dropped in light of direction for consideration of representation having been complied with.
Liberty will be reached. Please.
This matter, my lord, appears for the respondent. Comply the order of the.
Complied.
Civil judge.
Yes.
Permit to file. appeal.
Just now we have received, my lord, it may kindly be taken tomorrow or any other.
GA files affidavit and submits there is compliance of the order.
Next, sir, R15 is the endorsement is issued. my lord. Rejecting the request.
Relist tomorrow.
Tomorrow. Just now he has given.
Chepa, this is regarding regularization. The single bench has passed to consider the order, the letter of respondent number 2, your lordship, that is 12/6/2020. That has not been considered yet.
Applied the order of the civil judge. Filed the operator.
Copy has not been served yet.
Huh?
Copy has not been served.
Repeat. You have rejected it.
Yes, we also rejected.
Lordship.
But order is passed to my lord. Annexure R2, my lord. 7/1/2025, my lord, update is filed.
Lordship, a week's time may be granted, your lordship. I will seek necessary instructions.
Huh?
Just now they have served the copy of the affidavit. We
Correct.
will just go through it.
Correct. Now they've declined, you will have to challenge it. That
Yes.
is the only way.
Yes.
So we'll keep all objections.
No,
open.
I will just go through it.
I
Just
will
now they
pursue
have.
your
served.
lordship. It has become the practice of the government, whenever there is order for consideration. Consideration, it doesn't mean, my lord, that we have considered and rejected. In almost all the cases, I will pursue your lordship. That cannot be consideration.
Page number 19, my lord, order of the
Pardon?
single judge.
Any such positive direction, it has to be considered in favor of you. If there is no such positive
No,
direction.
my lord, what I am submitting, I will pursue your lordship. Just now he has given the copy and let me have a glance on the,
Relist, when do you want it?
pardon,
When do you want it? When do you want it?
any day.
Tomorrow?
Yes.
Relist tomorrow.
Please.
I appear for the complainant. I appear for the complainant.
Yeah.
There is a direction to regularize the services of petitioner from within 2 months. In page 18 is the order, operative portion.
I'm appearing for the respondent. Senior counsel is appearing through video conference. But anyhow, my lordship, we have filed writ appeal, my lord, it is pending before this.
Intra-court appeal is not maintainable. It is order of labor court, my lords.
My lordship, regarding that point, my.
The order is of labor court, my lord. Intra-court appeal is not maintainable.
What do you say regarding that position?
Regarding that maintainability also, we will try to convince my lordship on next date, my lord, because of our appeal is also pending. So along with that, my
Lord, one kind submission, my lord. This is all together, my lord. Matters may be taken up on fifth workshop. And SLP also pending consideration. Lord, SLP is pending consideration, my lord. Where regular has been sought for Lord batch matters, and that is this week's time that is coming up 15th, my lord. Along with that matter, my lord, that is contempt, my lord, proceedings 200234, day before yesterday's matter, my lord. It may be listed, and we will, my lord, try to convince my lordship, both, my lord.
Is the other matter?
my lordship, that is on 2002 FR number. FR number is writ appeal 200275 of 24.
200?
275 of 24. And another two matters are there, my lordship. I will furnish those number also to the court.
Your lordship may kindly peruse ink page 16, my lord.
Let us see. All matters will dispose of together.
Hello, sir. Your lordship may kindly have a glance. In para number 5, ink page 16. Under similar circumstances and similar matters, my lord, in respect of the KB only, the first, that is, writ petition was allowed in favor of the workmen for regularization. Writ appeal was preferred, and they went even up to Honorable Supreme Court. There was also, they suffered. That has been referred to in this para number 5 only. Now they are saying for seeking adjournment, my lord, let them file the appeal, SLP, or take any orders. We may not have any grievance. Just by filing and taking FR number and saying that we have preferred the appeal and seek adjournment means it will be, your lordship may kindly appreciate.
We have filed an appeal against this order. Huh? Okay, we'll have it. We'll see what is to be done in the appeal. We'll have it next week.
After filing, my lord, the modus operandi is after giving the notice of contempt, they will start preparing the appeal. And they will seek adjournments in contempt for several times. Thereafter, they will be coming and saying that they have preferred the appeal. This is a modus operandi.
Let us list along with the WAFR 200.
And this is intra-court appeal, my lord. In several cases, the same respondent has submitted and succeeded in getting the case disposed.
List on date code. 13th.
Oblige.
15th is the date given, my lord, day before yesterday's contempt matter. 15th, please, obliged much.
Obliged.
Appearing for petition. Senior in VC, my lordship.
My lordships, I appear for the petition in this case, my lordships. The order impugned is passed by the Karnataka Administrative Tribunal Kalaburagi bench at Annexure B, page number 36, my lordship, wherein I had filed a application before the KT seeking consideration of my representation with a writ of mandamus that has been rejected. Note, there is no intent, notice may be ordered, my lordship. Much obliged, my lords.
AGA is directed to accept notice for respondent 1 and 2.
Much obliged, my lords.
Copy kodi, please.
Connected matters, consent has to be filed by the.
We'll dismiss it for non-prosecution. 2015, what is this? You can't take things for granted.
Before the single judgment,
Single judge.
That's right.
And then it was posted to the division. But let him come, we'll at least tell him that he has to file. We'll pass over, let him at least know that, otherwise to next date again, they can all be clubbed and taken up. Enhancement or liability.
The two appeals, they have challenged liability. And one is for enhancement. First matter is for enhancement.
You are also appearing for the?
I'm for the owner, Lord. Earlier in 2015, I had filed for owner.
Okay, we'll let him come, we'll instruct him and then fix a date. Pass over.
My lords, and may it please the court. This matter, my lords, the previous bench had heard the case on merit itself. I had completed my argument also. The state's argument was pending, but for due to circumstances, it could not be taken up and matter was released from part heard. Now, my lords, if your lordship are willing to take up, because it will not take much time, I think I will not take more than 1 hour in this matter. So if your lordship is willing to take up a final hearing, any date at 2:30, I'll finish this matter itself.
Yes, you are in custody.
My lord, custody is very short custody, but the fact of the matter is this is a circumstantial evidence case.
And let's see your IA.
My lords. There are 2 IAs.
You filed your objection?
Yes. Long back.
So then you make your submissions regarding your the IA.
IA, my lords. My lords, so far as IA is concerned, my lord, initially the complaint was against unknown persons. FIR has charges of 376 rape and 302 murder, and body was found in such a state. It was found in a
Convicted for the offense?
Convicted for the offense of 302. 302. The deceased is a wife.
This is the wife of.
Wife of the appellant. But her body was found in some land, agriculture land. And the state of body was such that her clothes were all striven everywhere and it was in a semi-nude state. So the initial complaint was against unknown persons alleging rape and murder.
caused in the house or
No, no, outside,
outside?
in the agriculture land, very far away from the house.
How long you are in custody now?
My lords, as on the date of filing in 2023, 1.5 years.
You are on bail? In the
No, my lords, I was not on bail. I
in
was,
the course of that?
no, I was not, no, I was not on bail.
Not on bail.
So, my lords, so subsequently, my lords, a complaint was filed by PW1, the mother of the deceased. The case of the prosecution is,
The case based on eyewitness evidence? or
no, my lords, it's
circumstantial?
entirely based on circumstantial evidence. And none of the circumstances also proved.
Circumstance relied by the prosecution.
So prosecution circumstance is, my lords, which is not even, it can't even be addressed as circumstance. They say that I was a gambler, I was a drunkard, and I had incurred debt. And I was asking money from my wife. My wife has refused to give me money, so I decided to murder her.
What is that circumstance called?
That is the circumstance prosecution is projected.
You say,
Ma'am,
what are the circumstances? You last thing,
yes,
recovery.
my lords, motive is projected as my my habit, my debt, my debtness, my indebtedness, wherein I asked money from the wife refused to give. So therefore, there is animosity between me and my wife. Family relationship has strained. So that is the motive projected by the prosecution. Last seen theory, my lords, is what is shown by the prosecution. And the third thing, my lords, they say that the stone was recovered from the spot of from the scene of offense. So,
Who are all your children?
my lords,
Your children?
my children,
PW 11 and 14 are your children?
yes, my lords.
They are supported.
They have said that there was a strain in the relation between my mother and my father. That is a, they are not an eyewitness. They are hearsay witnesses. Hearsay. They have not seen the incident. Now, my lords, to balance the evidence of these children, I have filed an additional document.
Who are the witness for last scene theory?
Last scene theory, my lords, PW5, but he has not supported the case of prosecution. PW5, he has not supported the case of prosecution. Extrajudicial confession is also one of the
You made confession. You made extrajudicial confession.
confession before some
PW 8,
PW8. Now, my lords,
supported.
he has not supported, my lords.
Some extent he has supported.
Some, he has not supported. Insofar as saying that he has murdered me, that part is not supported. The incriminating part is not supported.
Yes, Mr. SP, what is all the witnesses were turned hostile?
My submission would be. My lords, the incident is said to have occurred on 3. For 10 days, what was the reason for absconding this particular appellant? And he has to explain. Soon after, when he came to know the murder of that particular lady who happens to be the wife of this appellant, my lord, he didn't whisper before the police or he telephonically called to the mother of the deceased. And he created a scene. Rape ಮಾಡಿದ್ದಾರೆ, ಸೀರೆ ಹೇಳ್ಬಿಟ್ಟು. And MO has been, stone has been recorded, my lords. And the
Incident caused not in the house. So 106 baralla.
no, my lords, a submission would be, incident has been occurred in his own land, man. In his own land. And also, my lord, the PW 11 and 14, how this appellant used to torture, the entire categorically they are stated. And even 164 statement has been recorded. Of course, PW 5 and 8 partly supported. Then also their evidence also has been recorded in section 164.
Year 23, he's on bail.
No.
He was not on bail, my lords.
He wasn't bail on.
1 year.
1.5 years.
He's been in this.
So I had convinced the court that it is a case which can be.
Yes, Barkuri. Order on IA 1 of 2023. This application of IA 1 of 23 filed under section 389 of CRPC seeking suspension of the sentence asked, the suspension of the sentence passed in SC number 148 of 2022 dated 28 July 2023 by the third additional district and session judge at Kalaburagi, full stop. The applicant is the appellant in the main appeal. He has challenged the judgment of conviction and order of sentence passed in the above stated session case number 148 of 2022, wherein the learned session judge has convicted the applicant for the offense punishable under section 302 and 201 of IPC and sentenced him for life imprisonment for the major offense of 302 of IPC, 302 of IPC, full stop. The summary of the prosecution case is that the PW 18, the investigation officer has laid a charge sheet against the accused for the homicidal death of one Shamala Bai with the wife of the appellant accused before the committal court, and thereafter, the case committed before the learned session judge and the learned session judge after a detailed trial convicted the accused for the charge leveled against him and sentenced him as stated supra. Full stop. It is the primary contention of the learned counsel for the appellant that all the material witness have turned hostile and the entire case rests on circumstantial evidence, and the prosecution has utterly failed to prove the chain link between chain link in the circumstance relied by the prosecution. Full stop. The application is vehemently opposed by the learned additional SPP, alleging that the trial court, after meticulously examining the evidence on record, passed the well-reasoned judgment, as such, the accused not entitled for the suspension of sentence and grant of bail. Full stop. We have carefully perused the impugned judgment and other materials placed before us. On perusal, admittedly, the case rests on circumstantial evidence, and the learned session judge has convicted the accused based on the evidence of PW 11 and 14 for the children of the deceased and accused appellant. Full stop. However, these two witnesses are hearsay witnesses to the incident. Full stop. The last here's witness. Full stop. PW, though the prosecution has examined PW 5 and 6 to prove the last scene theory, these two witnesses turned hostile to the prosecution case. Full stop. Further, the prosecution also relied the evidence of PW 8, before whom the accused has made extrajudicial confession. However, this said witness also turned hostile. In such circumstances, partly hostile. Full stop. In such circumstance, full stop. In such circumstance, without expressing any opinion on the merits of the case, suffice to hold that this appeal is of the year 2023, and there is no such possibility of hearing this appeal immediately in near future, by considering the law laid down by the Honorable Apex Court in the case of Kashmir Singh versus State of Punjab reported 1977, AR SC 2147, comma, we are of the considered view that the IA number 1 of 2023 we consider by imposing the conditions. Accordingly, IA 1 of 23 is allow subject to the condition that the appellate allow full stop. The substantive sentence imposed by the trial court in SC number so and so is hereby suspended, and the accused appellant is directed to release on bail pending disposal of this appeal subject to the condition that he shall execute it for a bond sum of rupees 1 lakh with the two sureties to the like sum for the satisfaction of the trial. He shall
procedure, therefore I am.
Sure.
That I take.
Correspondence 1 to 4. AGA accepts notice for the 5th respondent.
Let
This is the
notice
mat-
also.
This is the matter on 23.
Right.
Yes,
One
Notice.
before you notice ಮಾಡಿದ್ದು.
In addition, notice has to,
issued notice to 1
Yeah.
to.
great.
Pass over. Yes,
My lord, is it, my lord, I'm sorry, my lord. Is it, if it is, my lord, 18 serial number?
we can't hear you.
Please, my lord, there is a delay, my lord, in filing of appeal.
Which
And my lord,
matter?
FDP is also filed, my lord.
Which matter?
FDP, please, my lord, final decree proceedings, serial number 18, my lord. In that, my lord, I may be permitted to, my lord, to take a notice of this honorable court on the counsel appearing for, my lord, respondents in FDP proceedings.
18 issue
8 of
notice.
2024.
Issue notice on IA 1 of 24 and IA and B. I mean, the appellant is permitted to serve counsel appearing for the respondents in the final degree proceedings. You serve them and we'll give a date. On that day we'll consider.
Obliged, my lord. Please, much obliged.
Later on, week after next, 23rd. PCR to be summoned. Yes. That's all.
For applying the massive.
Time to file application. Day before yesterday, they served. Correct. What we are saying is,
My
it
lordship,
requires hearing. On terms,
I've
we
engaged
will
the
state, on terms, it's a money decree. On
I've-
terms,
I have engaged a counsel through VC, my
Huh?
lordship. I have engaged a counsel through VC, my
Huh.
lordship. He's connected.
this will
I appear for the appellant, my lords.
monitor ಸ್ವಲ್ಪ the indicated. Now we'll state on terms.
Yes, my lords.
How much you'll deposit?
25%, my lords.
Now it's a check dishonored, isn't it?
They say the check is dishonored, but I had also made payment to receipts, my lords. That has to be.
50% you deposit, we'll give you time. It will be in an interest bearing fixed deposit.
Yes.
There would be stay of the judgment and decree. Subject to deposit of 50% of the
Of the principal amount, my lords, not the interest.
12 lakhs.
$12,63,316.
deposit of 8 lakhs. Within how much time?
Seven lakhs, my lords.
7 lakhs within how many weeks?
4 weeks, my lords. 4 hours.
In 4 weeks from today. Needless to state, any failure to adhere to the condition will result in automatic vacation of the interim order granted. PCR to be summoned forthwith, list week after next. But
I will deposit for the court, my lords.
amount to be deposited before this court. On such deposit, amount to be kept in interest bearing fixed deposit. You try to settle it. Prima facie appears to be a difficult case. You try to settle it with the caveat.
Yes, my lords. Much obliged.
Obliged.
Here for the respondent.
List week after next. Yes. Yes, 20.
28 ಅಲ್ವಾ? Suspension ಅಲ್ಲಿ ಇದೆ.
Short accommodation. You have to file your objection. Yes. Next.
Monday. At the request of clerk, SPP, they notify upon them.
Case of departmental inquiry, my lord.
Case of,
Departmental inquiry.
then we have to hear it.
Yes, my lord.
Records,
Yes, my lord. And here
records. What is the punishment?
punishment of compulsory retirement from service, my lord, and there was an interim order of stay, my lord, even granted by this honorable court. But my lord, it was, my lord, not implemented. My lord, by the time, my lord, she was, my lord, relieved. So it's a case of, my lord, no evidence. And my lord, none of the prosecution witnesses, my lord, have, my lord, supported the charges.
You are ready?
Please, please.
Yes, are you ready?
Accommodation.
Huh?
Yes.
ನಮ್ಗೆ ಏನ್ ಗೊತ್ತಾ? Yes or no? ಅಷ್ಟೇ.
It will be taken on 17th, my lord. I have to go
We'll
through.
take in on that day you be ready because he's ready.
Please, my lord.
We'll hear and dispose it.
Please, my lord. It will be taken on 17th.
So what you are saying, there is no evidence at all.
No evidence, my lord. And my lord, in fact, my lord, even in the criminal proceedings also, my lord, I was, my lord, acquitted.
That will keep it aside for the present. But in so far as the inquiry, what there is no evidence.
There's no evidence, and even in both the, my lord, proceedings, my lord, the same witnesses were examined, and my lord was acquitted, and even the state appeal was also dismissed.
No, criminals, you keep it.
Yes, my lord. In so far as departmental inquiry is concerned, my lord, there is no evidence. And my lord, in fact, they have deposed, my lord, that I have not received any bribe money. And my lord, and even the punch witness also, my lord, has not supported the charges.
You make a synopsis.
Please.
What is the evidence, witnesses, what they've deposed? According to you, none of them have supported the
Yes, ma'am.
incident.
Yes, ma'am.
She admitted, my lord, she received the money and her hands were.
So even on the basis of the evidence of witnesses in the D, you're saying case is not made out.
Yes, my lord. And my lord, to be precise, my lord, I will read out, my lord, only a small, my lord, it's a statement in of PW 1 and 2. I will take only some 3 minutes, my lord. May I take kindly? Annexure, page 77, my lord, annexure A4. Page 77, annexure A4.
77.
Yes.
May I take, my lord, to the relevant, my lord, portion?
Yes.
77. 78 is a PW1, my lord, and the relevant, my lord, para 5.
Yes.
We left a look at, this is the, my lord, the version of the complainant. My lord, we left Lokaयुcta office and reached DDP office at about 4:15 PM. The vehicle was stopped about 200 meters away from DDP office. Myself and punch witness went inside the DDP office. Punch witness was standing near door and I went to meet DGO. When I inquired DGO, she informed that she has already completed work and asked to go to outward section. Therefore, I asked to receive 2,000. DGO refused to take. When I kept money on the table, she pushed the money. Money fell into the drawer. Punch witness gave a signal to police. Immediately, police took inside and asked DGO to take out and give money. DGO took out the money and handed over to the DGO. Police took the hand wash of DGO and it turned into pink color. The amount was tallied and found that it was the same which I presented before the Lokaयुcta police. Place of drawer was swabbed with the police with the help of cotton and dipped into solution. It turned into pink color. Police seized the documents pertaining to 14 students. DGO gave a statement before Lokaयुcta police. Police have drawn up the trap Mahazar EXP3 statement of DGO is marked ESP4. Copies of documents pertaining to students are marked as so and so. Copies of attendance registers marked so and so. Lokaयुcta arrested the DGO and took her to Lokaयुcta office. At the request of PO, witness is treated as hostile and permission is granted for cross-examination. It is false to say that DGO demanded rupees 200 per head to do the work and bargain. DGO agreed for rupees 2,000. And this conversation was recorded in mobile and mobile was produced before the IO. It is true that Sri Siddhangauda Mallana Patil kept money into my shirt pocket in Lokaयुcta office. It is false to say that when I went inside the office and approached DGO, DGO demanded rupees 2,000. Then I gave it to DGO. DGO received from her right hand and kept money in the drawer. It is false to say that DGO never refused to receive money. My lord, may I come to, my lord, para 10 and 11. On 25/8/2012, all the students had come with me to meet DGO. It is true that 25/8/12 DGO informed me that a part of work is completed and asked me to correct the year in all the applications. It is true that therefore students took me to Lokaयुcta office. It is true that in Lokaयुcta office, students also informed police that till today their work is not completed. It is true that the Lokaयुcta police informed me to get work completed
When
early.
you get ready, you prepare your synopsis.
Please.
We'll take it up on the next day.
Please.
You get ready. Who is the other witness?
Other is the punch witness, my lord, which is at PW2. PW2.
Correct, but now they say she refused to take.
No, they say, my lord, here the statement of her own that, my lord, she pushed aside the money. If the money is pushed, it will not go into the drawer. Then that will go outside the drawer. That itself is sufficient, my lord. She issued the money. And they merely they have hostile. They have turned hostile, therefore.
The work was not pending. So the question of him handing over the money to her doesn't affect.
Lordship, my lord, exam.
Received the money and it has turned.
Also, judicial review is very limited.
Yes,
As per Umesh, State of Karnataka versus Umesh.
Please.
Subsequent Ramlil case also. The only point is perversity and no evidence.
Yes, perversity and no evidence.
Perversity and
Yes, very much. I will prepare a synopsis, my lord, and my lord, I will argue on that. My lord, may I request on 16th, my lord?
16th, but 17th.
17th, my lord, some inconvenience, 20 or 21. On any date.
21st.
20, please.
I kindly seek apology. Till number 26 minutes. Writ appeal. I was held up in court hall number.
This is that?
26 minutes.
We have adjourned it to
Your lordship had heard the matter on the last occasion, my lords.
We wanted some time.
Yes, because my lords, if a kind permission, my lords, earlier, my lords, this honorable court had heard the matter substantially, my lords, and the government advocates were directed to submit a report also, my lords. They have submitted report on last date of hearing, my lords, and detailed order was passed by this honorable court to, because wherein, my lords, 27 acres was acquired.
The date, we'll hear it, we'll fix the
Please.
date. The date. 23rd,
Please, my lords,
we'll hear on it.
please, my lords. Oblige, my lords. I'm sorry, my lords, I was held up in other.
That's it.
Oblige.
Time ಇದೆ ನೋಡ್ರಿ, no pass over. Time ಇದೆ ನೋಡ್ರಿ. Pass over.
My
What is
lords,
this matter?
This matter, but my lords, the notification passed by the chairman of the Karnataka State Administrative Tribunal was challenged before my lords only, my lords. Wherein we have filed an application before the Karnataka State Administrative Tribunal, inter se challenging the seniority of the range forest officers. Wherein when the matter was pending, my lords, the respondents have taken an objection that the matters concerning promotion, seniority have to be heard by the principal bench. That notification passed by the chairman of the KSCT was challenged before this court by way of writ petition. Before the transferring the matter application to the principal bench, Bangalore, they have not heard us. My lords have stayed in the month of September, my lords. The senior counsel, I have engaged with the services of senior counsel, my lords. He is on the next.
State, you get ready on this. My lord, you get ready by the next state.
Even the KSAT chairman has appeared through advocate, my lords, and he has filed objection yesterday, my lords. Yesterday they have filed objections.
Let us, we'll hear it.
Interim order needs to.
Interim order earlier grant is extended till the next date. Relist on.
Any date to the convenience of respondents and government. Respond number one, KSAT is the main contesting party. Raghavendra Gayatri ಅಂತ ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ, ಇವತ್ತು ಯಾಕೋ ಅವ್ರು ಇಲ್ಲ ಸರ್.
Date. 28.
28. Oblige.
Appellate appeal against conviction, lords. Just pass on the synopsis, my lord. I've made a brief synopsis. W1 is the complaint, my lord. Charge could be found at page 44 of the paper book, my lords. Page 44 of the paper book is the charge, my lord.
44, huh?
Yes, my lord. May I read that, please?
Yes, yes.
Accused Ram son of Timmanna Gubbewad alias so and so. That you accused Ram son of Timmanna Gubbewad alias Gollar on 1/6/2015 at about 4 AM in the morning in the tin shed bearing khata number 1404 belongs to Timmanna son of Bhimmanna Gollar, situated at Gollar Street, Ward number 12 at Sindagi town, within the limits of Sindagi police station.
Wait a minute, this is your rented house, huh?
It belongs to my uncle.
Rented,
Yes.
rented house. You both are staying in the rented house?
Yes.
Yes. Hmm. Yes, continue.
Within the limits of Sindagi police, suspecting chastity of your wife, Sridevi, and angry that she did not pay money to you, drink liquor with an intention to commit murder, put the plastic wire Bombay Ghat as noose around neck of your wife Sridevi, wife of Ram Gubbewad, and tightly pulled the wire, smothered and committed murder by intentionally causing death of your wife Sridevi, and thereby you accused have committed an offence under 302 of IPC and within the cognizance of this court of session.
Charge only for 302.
Yes, ma'am.
So conviction for 302.
Yes, ma'am.
What is the sentence?
Life imprisonment.
Life, till life or rest of the life or life or until life? Life.
Yes, ma'am. And life imprisonment.
Yes. Now come to the complaint.
Exhibit P1, my lords,
Hmm.
at page 3 of the paper book.
Hmm.
The
Who
complaint
lodged
is
the
the
complaint?
grandmother of the deceased.
Grandmother.
Of the deceased.
Examined as?
PW1, my lords.
Yes, read the complaint.
ನಾನು ಯಲ್ಲವ್ವ ಗಂಡ ಯಲ್ಲಪ್ಪ ಮಣ್ಣೂರು, ವಯಸ್ಸು so and so. ನಾನು ಈ ಮೇಲಿನ ವಿಳಾಸ ಕೂಲಿ ಕೆಲಸ ಮಾಡುವಾಗಿ ವಾಸವಾಗಿದ್ದು ನನ್ನ ಮೊಬೈಲ್ ಸಂಖ್ಯೆ so and so ಇದ್ದು ನನಗೆ 8 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳಿದ್ದು 2 ಗಂಡಸು ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ಹೆಣ್ಣು ಮಕ್ಕಳ ಪೈಕಿ ಶರಣವಳಿಗೆ ವಿಜಯಪುರದ ಹನುಮಂತಹಳ್ಳಿ ಇವನಿಗೆ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದು, ಸುನೀತಾ ಹಾಗೂ ಅನಿತಾ ಇವರಿಗೆ ಸಿಂದಗಿ ಪಟ್ಟಣದ ರಾಮು ಬ್ಯಾಕ್ವರ್ಡ್ ಹಾಗೂ ಭೀಮಾ ಜಲವಾದಿ ಇವರನ್ನು ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತೇನೆ. ನನ್ನ 3ನೇ ಮಗಳ ಶರಣವ ಗಂಡ ಹನುಮಂತಹಳ್ಳಿ ಇವಳಿಗೆ 3 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳು ಹಾಗೂ ಒಬ್ಬ ಗಂಡಸು ಮಗ ಇರುತ್ತಾನೆ. ನನ್ನ ಮೊಮ್ಮಗಳಾದ ಶ್ರೀದೇವಿಗೆ ಈಗ 6 ವರ್ಷದ ಹಿಂದೆ ಸಿಂದಗಿ ಪಟ್ಟಣದ ರಾಮು ತಂದೆ ತಿಮ್ಮಣ್ಣ ಗುಬ್ಬೆವಾಡ್ ಅಪಲೆಂಟ್ ಹೇರು. Sridevi is the deceased, my lords. ತಿಮ್ಮಣ್ಣ ಗುಬ್ಬೆವಾಡ್ ಉಪ್ಪಾರ್ ಗೊಲ್ಲಾರ್ ಈತನಿಗೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ. ಈಗ 4 ತಿಂಗಳ ಹಿಂದೆ ನನ್ನ ಮಗಳಾದ ಶರಣವ ಇವಳು ತೀರಿಕೊಂಡಿರುತ್ತಾಳೆ. ಈಗ ಸುಮಾರು 3-4 ವರ್ಷಗಳಿಂದ ನನ್ನ ಮೊಮ್ಮಗಳು ಶ್ರೀದೇವಿಗೆ ಅವಳ ಗಂಡನಾದ ರಾಮು ತಂದೆ ತಿಮ್ಮಣ್ಣ ಗುಬ್ಬೆವಾಡ್ ಉಪ್ಪಾರ್ ಗೊಲ್ಲರ್ ಈತನು ಅವಳ ಮೇಲೆ ಸಂಶಯ ಮಾಡಿ ಜಗಳ ತೆಗೆದು ಹೊಡೆಬಡೆ ಮಾಡಿ ಮತ್ತು ಸರಾಯಿ ಕುಡಿಯಲು ಹಣ ಕೊಡುವಂತೆ ಹೊಡೆಬಡೆ ಮಾಡಿ ಅವಳ ತವರು ಮನೆಯಾದ ವಿಜಯಪುರಕ್ಕೆ ಕಳಿಸಿಕೊಟ್ಟಾಗ ನನ್ನ ಮಗಳಾದ ಶರಣಮ್ಮಳು ತನ್ನ ಮಗಳು ಶ್ರೀದೇವಿಗೆ ಅವಳ ಗಂಡ ಹೊಡೆಬಡಿ ಮಾಡಿ ಕಳಿಸಿಕೊಟ್ಟಿರುತ್ತಾನೆ ಅಂತ ತಿಳಿಸಿದಾಗ ನಾನು ಸಿಂದಗಿಗೆ ಬಂದು ನನ್ನ ಮೊಮ್ಮಗಳ ಗಂಡನಿಗೆ ಸಿಂದಗಿ ಶಹರದ ಸಮಾಜದ ಹಿರಿಯರಿಗೆ ಕೂಡಿಸಿ ಮೊಮ್ಮಗಳಿಗೆ ಹೊಡೆಬಡೆ ಮಾಡದಂತೆ ಬುದ್ಧಿವಾದ ಹೇಳಿ 3-4 ಸಲ ಹೋಗಿದ್ದೆವು. ಆದರೂ ಸಹ ಮೊಮ್ಮಗಳ ಗಂಡ ರಾಮು ಈತನು ಕುಡಿಯಲು ಹಣ ಕೇಳಿದ್ದು ಅದಕ್ಕೆ ಅವಳಿಗೆ ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಾ ಬಂದಿರುತ್ತಾನೆ. ಈಗ 1 ತಿಂಗಳ ಹಿಂದೆ ನನ್ನ ಮೊಮ್ಮಗಳಾದ ಶ್ರೀದೇವಿಯವಳು ಫೋನ್ ಮಾಡಿ ತನ್ನ ಗಂಡ ತನ್ನ ಮೇಲೆ ಸುಮ್ಮನೆ ಸಂಶಯ ಪಡುತ್ತಾ ಕುಡಿಯಲು ಹಣ ಕೊಡು ಅಂತ ಜಗಳ ತೆಗೆದು ಹೊಡೆಬಡೆ ಮಾಡಿರುತ್ತಾನೆ. ನೀನು ಬಾ ಅಂತ ತಿಳಿಸಿದಾಗ ನಾನು ಸಿಂಧಿಗೆ ಬಂದು ಮೊಮ್ಮಗಳ ಗಂಡ ರಾಮನಿಗೆ ನನ್ನ ಅಳಿಯಂದರು ಹಾಗೂ ಹೆಣ್ಣು ಮಕ್ಕಳ ಸಮಕ್ಷಮದಲ್ಲಿ ಇಬ್ಬರಿಗೂ ಬುದ್ಧಿವಾದ ಹೇಳಿ ಸರಿಯಾಗಿ ಸಂಸಾರ ಮಾಡಿಕೊಂಡು ಹೋಗಿರಿ ಅಂತ ಮೊಮ್ಮಗಳಿಗೆ ಹಾಗೂ ಆಕೆಯ ಗಂಡನಿಗೆ ಬುದ್ಧಿ ಮಾತು ಹೇಳಿ ಹೋಗಿದ್ದೆವು. ಈ ದಿವಸ ದಿನಾಂಕ 1/6/2015 ಬೆಳಿಗ್ಗೆ 6 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಾನು ನಮ್ಮೂರಿನಲ್ಲಿ ಇದ್ದಾಗ ನನ್ನ ಹಳೆಯನಾದ ರಾಮ್ ತಂದ ಗುರಪ್ಪ ಬ್ಯಾಕೋಡ್ ಈತನು ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿದ್ದೇನೆ, ನಿನ್ನ ಮೊಮ್ಮಗ ಶ್ರೀದೇವಿ ಅವಳ ಗಂಡನಾದ ರಾಮ್ ತಂದೆ ತಿಮ್ಮಣ್ಣ ಗುಬ್ಬಾಡ್ ಉಪ್ಪಾರ್ ಈತನು ರಾತ್ರಿ 11 ಗಂಟೆಯಿಂದ ಈ ದಿವಸ ಮುಂಜಾನೆ 6 ಗಂಟೆ ನಡುವಿನ ಸಮಯದಲ್ಲಿ
ನನ್ನ ಅಳಿಯನಾದ ರಾಮ ಯಾರು? Who is this Rama?
He is another CW9 PW
He examined.
Yes, yes, yes.
PW
9 minutes.
PW9.
Yes,
The name is same.
Same name, same.
So, 11 ಗಂಟೆ ಈ ದಿವಸ ಮುಂಜಾನೆ 6 ಗಂಟೆ ನಡುವಿನ ಸಮಯದಲ್ಲಿ ಪ್ಲಾಸ್ಟಿಕ್ ವೈರ್ ಬಾಂಬೆ ಘಾಟದಿಂದ ಕುತ್ತಿಗೆ ಬಿಗಿದು ಕೊಲೆ ಮಾಡಿರುತ್ತಾನೆ ಅಂತ ತಿಳಿಸಿದನು. ಆಗ ನಾನು ಗಾಬರಿಯಾಗ ನನ್ನ ಮಗ ಜಗದೀಶ್ ಊರ ಹಿರಿಯರಿಗೆ ತಿಳಿಸಿ, ನಾನು ಆಗ ನನ್ನ ಮಗ ಜಗದೀಶ್ he is examined as PW 10 minutes. ಜಗದೀಶ್ ಹಾಗೂ ಊರ ಹಿರಿಯ ತಿಳಿಸಿ, ನಾನು ಹಾಗೂ ನನ್ನ ಜಗದೀಶ್ ಊರ ಹಿರಿಯಾದ ಜ್ಯೋತಿಬಾ ತಂದೆ ನಿಂಗಪ್ಪ, ತುಕಾರಾಮ್ ತಂದೆ ಅಂಬಣ್ಣ, ಅಂಜಪ್ಪ, ಅಂಬಾಣ, ತುಳಜಪ್ಪ ಹಾಗೂ ವಗೇರೆ ಜನರು ಕೂಡಿ ಒಂದು ಜೀಪ್ ಮಾಡಿಕೊಂಡು ಸಿಂದಗಿ ಪಟ್ಟಣದ ರಾಮ್ ತಂದೆ ತಿಮ್ಮಣ್ಣ ಗುಬ್ಬಾಡ್ ಉಪಾರ್ ಗೊಲ್ಲಾರ್ ಈತನ ಮನೆಗೆ ಬಂದಾಗ ಮನೆಯಲ್ಲಿ ನನ್ನ ಮೊಮ್ಮಗಳಾದ ಶ್ರೀದೇವಿ ಗಂಡ ರಾಮ್ ಗುಬ್ಬಾಡ್ ಉಪ್ಪಾರ್ ಗೊಲ್ಲಾರ್ ವಯ 24 ವರ್ಷ ಅಂಗಾತವಾಗಿ ಪತ್ರಾ ಶೆಡ್ಡಿನಲ್ಲಿತ್ತು. ಅವಳ ಕುತ್ತಿಗೆಯಲ್ಲಿ ಸುತ್ತಲೂ ಕಪ್ಪಾದ ಮಾರ್ಕ್ ಇತ್ತು. ಅಲ್ಲಿಯೇ ಇದ್ದ ನನ್ನ ಮಗಳಾದ ಸುನೀತಾ ಇವಳಿಗೆ ವಿಚಾರಿಸಿದಾಗ ಶ್ರೀದೇವಿ ಗಂಡನಾದ ರಾಮ್ ಈತನು ನಿನ್ನೆ ದಿವಸ ಸಾಯಂಕಾಲ ಜಗಳ ಮಾಡಿದ್ದು ನಿನ್ನೆಯ ದಿವಸ ರಾತ್ರಿ 11 ಗಂಟೆಯಿಂದ ಮುಂಜಾನೆ 6 ಗಂಟೆ ನಡುವಿನ ಅವಧಿಯಲ್ಲಿ ತನ್ನ ಮನೆಯಲ್ಲಿ ಪ್ಲಾಸ್ಟಿಕ್ ವೈರ್ ಬಾಂಬೆ ಘಾಟದಿಂದ ಕುತ್ತಿಗೆ ಬಿಗಿದು ಕೊಲೆ ಮಾಡಿರುತ್ತಾನೆ ಅಂತ ತಿಳಿಸಿದಳು. ನಾವು ಶವ ನೋಡಿದಾಗ ಈ ಸುನೀತಾ is examined as PW 8 minutes.
PW 8.
Yes.
The other daughter, another daughter.
Yes, another
From
daughter.
company.
The wife of the PW9.
She is residing there only, huh?
Yes,
Near the house of deceased.
nearby house.
Yes.
ಕುತ್ತಿಗೆ ಬಿಗಿದು ಕೊಲೆ ಮಾಡಿ ತಿಳಿಸಿದರು. ನಾವು ಶವ ನೋಡಿದ ಈ ದಿವಸ ಮುಂಜಾನೆ 9:15 ಗಂಟೆ ಆಗಿರಬಹುದು. ಮೇಲೆ ನಮೂದಿಸಿದ ನನ್ನ ಮೊಮ್ಮಗಳಾದ ಶ್ರೀದೇವಿ ಗಂಡ ರಾಮ್ ಗುಬ್ಬೆವಾಡ್ ವಯ 27 ಮೇಲೆ ಅನೈತಿಕ ಸಂಬಂಧದ ಬಗ್ಗೆ ಸಂಶಯ ಪಟ್ಟು ಹಾಗೂ ಸರಾಯಿ ಕುಡಿಯಲು ಹಣ ಕೊಡಲಾರದಕ್ಕೆ ಶ್ರೀದೇವಿ ಮೇಲೆ ಅವಳ ಗಂಡ ಸಿಟ್ಟಾಗಿ ದಿನಾಂಕ 31/5/2015 ರಾತ್ರಿ 11 ಗಂಟೆಯಿಂದ ದಿನಾಂಕ 1/6/2015 ಮುಂಜಾನೆ 6 ಗಂಟೆ ವೇಳೆಯಲ್ಲಿ ತನ್ನ ಹೆಂಡತಿಯಾದ ಶ್ರೀದೇವಿಗೆ ಅವಳ ಗಂಡ ರಾಮ್ ತಂದೆ ತಿಮ್ಮಣ್ಣ ಗುಬ್ಬಾಡ್ ಸೋ ಈತನು ಪ್ಲಾಸ್ಟಿಕ್ ವೈರ್ ಇಂದ ಕುತ್ತಿಗೆ ಬಿಗಿದು ಕೊಲೆ ಮಾಡಿದ್ದು ಸದರಿ ರಾಮ್ ತಂದೆ ತಿಮ್ಮಣ್ಣ ಗುಬ್ಬಾಡ್ ಈತನ ಮೇಲೆ ನನ್ನದು ಫಿರ್ಯಾದಿ ಇರುತ್ತದೆ.
So she lodged this complaint exhibit P1.
Yes, madam. Thereafter, the appellant is arrested on 2/6/2017. Next day is arrested.
Yes.
My lord, PW2 is a pancha to the spot Mahajan, my lord. He has turned hostile to the prosecution case.
Now come to the evidence of PW1.
Yes, madam. Page 47 of the paper book, my lords. May I read? ಆರೋಪಿ ಗೊತ್ತು. ಆರೋಪಿ ನನ್ನ ಮಗಳಾದ ಶ್ರೀದೇವಿ ಇವಳ ಗಂಡ. ಶ್ರೀದೇವಿ ಇವಳ ಮದುವೆ ಆರೋಪಿಯ ಜೊತೆ ಸುಮಾರು 8 ವರ್ಷದ ಹಿಂದೆ ಆಯಿತು. ಮದುವೆ ಆದ ಮೇಲೆ ಆರೋಪಿ ಮತ್ತು ಶ್ರೀದೇವಿ ಸಿಂದಗಿಯಲ್ಲಿ ಶೆಡ್ಡಿನಲ್ಲಿ ಇದ್ದರು. ಲಗ್ನ ಆದ ಮೇಲೆ ಶ್ರೀದೇವಿ ಸಂಸಾರ ಮಾಡಲು ಆರೋಪಿ ಜೊತೆ ಹೋದಳು. ಶ್ರೀದೇವಿ ತಾಯಿ ಶರಣವ ನನ್ನ ಮಗಳು. ಸದರಿ ಶರಣವ ಈ ಘಟನೆ ಆಗುವುದಕ್ಕಿಂತ 4 ತಿಂಗಳ ಮುಂಚೆ ಸತ್ತು ಹೋಗಿದ್ದಳು. ಆರೋಪಿ ಕುಡಿದು ಬಂದು ಹೆಂಡತಿಯ ಮೇಲೆ ಜಗಳವಾಡುತ್ತಿದ್ದನು. ನನ್ನ ಹತ್ತಿರ ನ್ಯಾಯ ಪಂಚಾಯತಿ 2 ಸಲ ಬಂದಿದ್ದರು ಮತ್ತು ನನ್ನ ಮಗಳು ಶರಣವಿಗಳ ಹತ್ತಿರ ನ್ಯಾಯ ಪಂಚಾಯತಿಗೆ 2 ಸಲ ಬಂದಿದ್ದರು. ನನ್ನ ಹತ್ತಿರ ಪಂಚಾಯತಿಗೆ ಬಂದಾಗ ನೀವಿಬ್ಬರು ಸರಿಯಾಗಿ ಇದ್ದುಕೊಂಡು ಹೋಗಿ ಎಂದು ಹೇಳಿ ಕಳಿಸಿದ್ದೆ. ಹೀಗೆ ಸುಮಾರು 2 ವರ್ಷದ ಹಿಂದೆ ನಾನು ನಮ್ಮ ಮನೆಯಲ್ಲಿದ್ದಾಗ ನಮ್ಮ ಹಳೆಯ ಚಾಸ 9 ರಾಮ್ ಬ್ಯಾಕೋಡ್ ಇವನು ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 7 ಗಂಟೆಗೆ ನನಗೆ ಫೋನ್ ಮಾಡಿ ಶ್ರೀದೇವಿ ಅವಳ ಗಂಡ ಆರೋಪಿ ಅವಳ ಕುತ್ತಿಗೆಗೆ ಪ್ಲಾಸ್ಟಿಕ್ ವೈರ್ ಹಾಕಿ ಸಾಯಿಸಿದ್ದಾನೆಂದು ಹೇಳಿದನು. ಆಗ ನಾನು, ನನ್ನ ಮಗ ಜಗದೀಶ್, ಜ್ಯೋತಿಬಾ, ತುಕಾರಾಮ್, ಅಂಬಣ ಎಲ್ಲರೂ ಸೇರಿ ವಾಹನದ ಸಿಂದಗಿ ಕೊಲೆಯಾಗಿದ್ದ ಮನೆಗೆ ಹೋದೆವು. ಅಲ್ಲಿ ನಾವು ನೋಡಿದಾಗ ಶ್ರೀದೇವಿ ಹೆಣ ಕೊಲೆಯಾಗಿ ಅಲ್ಲಿ ಬಿದ್ದಿತ್ತು. ನಾವು ಅಲ್ಲಿಗೆ ಹೋದಾಗ ಬೆಳಗ್ಗೆ 10 ಗಂಟೆ ಆಗಿತ್ತು. ನಾನು ನೋಡಿದಾಗ ಶ್ರೀದೇವಿ ಕುತ್ತಿಗೆಯಲ್ಲಿ ವೈರ್ನ ಮಾರ್ಕ್ ಇತ್ತು. ನಂತರ ನಾನು ಸಿಂದಗಿ ಪೊಲೀಸ್ ಠಾಣೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೆ. ಕಂಪ್ಲೇಂಟ್ ಅನ್ನು ನನ್ನ ತಂಗಿಯ ಮಗ ಮೆಹಬೂಬ್ ಇವನ ಕಡೆಯಿಂದ ಹೇಳಿ ಬರೆಸಿ ಕೊಟ್ಟಿದ್ದೇನೆ. ನಾನು ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಾಗ ಬೆಳಗ್ಗೆ 11ರಿಂದ 12 ಗಂಟೆ ಆಗಿತ್ತು. ಸಾಕ್ಷಿ ಗುರುತಿಸಿದ ಫಿರ್ಯಾದಿ ನೀಪಿ 1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸಾಕ್ಷಿ ಫಿರ್ಯಾದಿ ನಾನು ಹೆಬ್ಬಟ್ಟು ಗುರುತು ಹಾಕಿದ್ದೇನೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ನಂತರ ಪೊಲೀಸರು ಅದೇ ದಿನ ಘಟನೆಯಾದ ಸ್ಥಳಕ್ಕೆ ಬಂದರು, ಪಂಚನಾಮ ಮಾಡಿದರು, ಫೋಟೋ ತೆಗೆದುಕೊಂಡರು. ಆ ಫೋಟೋಗಳನ್ನು ನೋಡಿದರೆ ಗುರುತಿಸುತ್ತೇನೆ. ಸಾಕ್ಷಿ ಗುರುತಿಸಿದ 2 ಫೋಟೋಗಳನ್ನು ನೀಪಿ 2 ಮತ್ತು 3 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸದರಿ ಫೋಟೋಗಳಲ್ಲಿ ಶ್ರೀದೇವಿ ಕಾಣುತ್ತಿದ್ದಾಳೆ ಮತ್ತು ಒಂದು ಫೋಟೋದಲ್ಲಿ ನಾನು ಇದ್ದೇನೆ. ನಂತರ ಪೊಲೀಸರು ಶವವನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋದರು. ನಂತರ ಪೊಲೀಸರು ಶವವನ್ನು ನಮಗೆ ಕೊಟ್ಟ ಮೇಲೆ ನಾವು ಅಂತ್ಯಕ್ರಿಯೆ ಮಾಡಿದ್ದೆವು. ಶ್ರೀದೇವಿ ಮೈ ಮೇಲೆ ಆ ದಿನ ಇದ್ದ ಬಟ್ಟೆ ನೋಡಿದರೆ ಗುರುತಿಸುತ್ತೇನೆ. ಆ ದಿನ ಶ್ರೀದೇವಿ ಮೈ ಮೇಲೆ ಸೀರೆ, ಲಂಗ, ಜಂಪರ್ ಇದ್ದವು. ಶ್ರೀದೇವಿ ಶವದ ಮೈ ಮೇಲೆ ಇದ್ದ ಸೀರೆ, ಲಂಗ, ಜಂಪರ್ ಮತ್ತು ಈಗ ನಾನು ಕೋರ್ಟಿನ ಮುಂದೆ ಗುರುತಿಸಿದ ವಸ್ತುಗಳಾಗಿರುತ್ತವೆ. ಸದರಿ ಸೀಲಾಗಿದ್ದ ವಸ್ತುಗಳು ನ್ಯಾಯಾಲಯ ತೆಗೆದು ಸಾಕ್ಷಿಗೆ ತೋರಿಸಿದೆ. ಸಾಕ್ಷಿ ಗುರುತಿಸಿದ ಸೀರೆ, ಲಂಗ, ಜಂಪರ್ ಮತ್ತು ಇವುಗಳು ಕ್ರಮವಾಗಿ MOO 1ರಿಂದ 4 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನನ್ನ ಮಗಳಾದ ಸುನೀತಾ ಇವಳನ್ನು ಸಿಂದಗಿ ಕೊಟ್ಟಿದ್ದೇನೆ. ನನ್ನ ಮಗಳಾದ ಸುನೀತಾ ಇವಳನ್ನು ನಾನು ಕೇಳಿದಾಗ ಶ್ರೀದೇವಿ ಗಂಡ ವೈರ್ನಿಂದ ಅವಳ ಕುತ್ತಿಗೆ ಬಿಗಿದು ಸಾಯಿಸಿದನೆಂದು ಹೇಳಿದಳು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ಅಲ್ಲ, PW9 ಗೆ ಬನ್ನಿ ನೋಡ್ರು. PW9 ನೋಡಲ್ಲ. PW9
yes
Rama, who informed PW1?
yes
Page number 76.
Page number 75 of the paper book.
It's the son-in-law of PW1.
Yes. Prior to that, may I draw my lord's attention to evidence of PW6, who is said to be the witness before whom the appellant would go and confess about make an extrajudicial confession.
PW6,
she has turned hostile, my lords.
Okay.
It is before PW6. The case is that I would go and confess. PW6.
Who is PW6? The neighbor?
Yes, my lords.
It's PW6.
Yellava Gullar. She is turned page 66, my lord. ಆರೋಪಿ ಗೊತ್ತು, ಅವನ ಹೆಂಡತಿ ಶ್ರೀದೇವಿ ಗೊತ್ತು, ಶ್ರೀದೇವಿ ಅಜ್ಜಿ ಫಿರ್ಯಾದಿ ಗೊತ್ತು. ನಾನು ಸಿಂದಗಿ ಗೊಲ್ಲರೋಣೆಯಲ್ಲಿ ಇದ್ದೇನೆ. ಆರೋಪಿ ಸಿಂದಗಿಯ ಗೊಲ್ಲರೋಣೆಯಲ್ಲಿ ಇರುತ್ತಾನೆ ಹಾಗೂ ಗುಬ್ಬೇವಾಡದಲ್ಲಿ ಇರುತ್ತಾನೆ. ಆರೋಪಿ ಜೊತೆ ಸಿಂದಗಿಯ ಗೊಲ್ಲರೋಣೆಯ ಮನೆಯಲ್ಲಿ ಯಾರ್ಯಾರು ಇರುತ್ತೆಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Yes. Sir, PW9 ಮುಲರ್ಸ್.
PW9 ಏನ್ ಹೇಳ್ತಾರೆ?
Page 75. May I read, ಮುಲರ್ಸ್? CW 8 ಸುನೀತಾ ನನ್ನ ಹೆಂಡತಿ, ಚಾಸ 1 ಎಲ್ಲವ್ವ ನನ್ನ ಅತ್ತೆ, ಮೃತ ಶ್ರೀದೇವಿ ನನ್ನ ಹೆಂಡತಿಯ ಅಕ್ಕನ ಮಗಳು. ಆರೋಪಿ ಗೊತ್ತು, ಆರೋಪಿ ಶ್ರೀದೇವಿಯ ಗಂಡ. ಅವರಿಬ್ಬರಿಗೆ 6 ವರ್ಷದ ಒಬ್ಬ ಮಗನಿದ್ದಾನೆ. ಅವರ ಲಗ್ನ ಆಗಿ ಈಗ 7-8 ವರ್ಷ ಆಯಿತು. ಆರೋಪಿ ಮತ್ತು ಅವನ ಹೆಂಡತಿ ಶ್ರೀದೇವಿ ಸಿಂದಗಿಯ ಓಣೆಯಲ್ಲಿ ಪತ್ರಾಸ್ ಶೆಡ್ಡಿನಲ್ಲಿ ಇದ್ದರು. ಮದುವೆಯಾದ ಮೇಲೆ ಆರೋಪಿ ತನ್ನ ಹೆಂಡತಿ ಶ್ರೀದೇವಿ ಕುಡಿಯಲು ನನಗೆ ರೊಕ್ಕ ಕೊಡು ಎಂದು ಹೊಡೆಯುತ್ತಿದ್ದ. 2-3 ಸಲ ನಾನು ನನ್ನ ಹೆಂಡತಿ ಬಿಡುತ್ತಿದ್ದೆವು. ಹೀಗೆ 2 ವರ್ಷದ ಹಿಂದೆ ನಾನು ಮನೆಯಲ್ಲಿದ್ದಾಗ ಮುಂಜಾನೆ 6 ಗಂಟೆಗೆ ಆಜುಬಾಜು ಹುಡುಗರು ನನ್ನ ಹೆಂಡತಿ ಕಸ ಗುಡಿಸುತ್ತಿದ್ದಾಗ ಬಂದು ನಿಮ್ಮ ಶ್ರೀದೇವಿಗೆ ಅವಳ ಗಂಡ ಹೊಡೆದು ಸಾಯಿಸಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದರು. ಆಗ ನಾನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಆರೋಪಿಯ ಮನೆಗೆ ಹೋಗಿ ನೋಡಿದಾಗ ಶ್ರೀದೇವಿ ಸತ್ತು ಹೋಗಿದ್ದಳು. ಹೆಣವನ್ನು ನೋಡಿದಾಗ ಆರೋಪಿ ತನ್ನ ಹೆಂಡತಿಗೆ ಹೊಡೆದಿದ್ದ ಜನ ಸೇರಿದ್ದರು. ನಂತರ ನಮ್ಮ ಅತ್ತೆ ಚಾಸ 1 ಎಲ್ಲವ ಇವರು ಪೊಲೀಸರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು. ಇಷ್ಟು ವಿಷಯ ಬಿಟ್ಟು ಬೇರೆ ವಿಷಯ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಶ್ರೀದೇವಿ ಮೇಲೆ ಬಟ್ಟೆಗಳು ನೋಡಿದ್ರೆ ಗುರುತಿಸುತ್ತೇವೆ. ಪಾಟ್ಲಿಗೆ ಫಸ್ಟ್.
Now the wife of this PW9 who informed to the complainant.
Yes, ma'am.
ಹೆಸರೇನು ಅವರದು?
PW8. ಸುನೀತಾ
ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ?
Page 72, my lords. She is also partly hostile, my lords. ಫಿರ್ಯಾದಿ ಎಲ್ಲವ ನನ್ನ ತಾಯಿ, ನನ್ನನ್ನು ಸಿಂದಗಿಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಸಿಂದಗಿಯಲ್ಲಿ ನಮ್ಮ ಮನೆ ಗೊಲ್ಲರೋಣಿಯಲ್ಲಿದೆ. ಆರೋಪಿ ಗೊತ್ತು, ಶ್ರೀದೇವಿ ನನ್ನ ಅಕ್ಕ ಶರಣವ್ವ ಇವಳ ಮಗಳು. ಶ್ರೀದೇವಿ ಆರೋಪಿ ಮದುವೆ ಆಗಿದ್ದು ಅವರಿಬ್ಬರು ಸಿಂದಗಿಯ ಗೊಲ್ಲಾರೋಣಿಯಲ್ಲಿ ಪತ್ರಾಸ್ ಮನೆಯಲ್ಲಿದ್ದರು. ಆರೋಪಿ ಕುಡಿದು ಬಂದು ಅವನ ಹೆಂಡತಿ ಶ್ರೀದೇವಿಯ ಜೊತೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದ. ತನ್ನ ಹೆಂಡತಿಗೆ ರೊಕ್ಕ ಕೊಡು ಎಂದು ಜಗಳ ಮಾಡುತ್ತಿದ್ದ. 2-3 ಸಲ ಅವರು ನಮ್ಮ ಮನೆಗೆ ಬಂದಿದ್ದರು. ಆಗ ನಾನು ಅವರಿಗೆ ಸರಿಯಾಗಿ ಇದ್ದುಕೊಂಡು ಹೋಗಿ ಎಂದು ಹೇಳ ಕಳಿಸಿದ್ದೆ ಮತ್ತು ಯಾವುದರ ಸಲುವಾಗಿ ಆರೋಪಿ ಶ್ರೀದೇವಿ ಮೇಲೆ ಜಗಳತಿದ್ದು ಅಂದು ಗೊತ್ತಿಲ್ಲ. ಈಗ ಸುಮಾರು 2 ವರ್ಷದ ಹಿಂದೆ ಆರೋಪಿ ಶ್ರೀದೇವಿ ವೈರ್ ಹಾಕಿ ಸಾಯಿಸಿದ್ದಾನೆ. ಆಗ ನಾವು ನಮ್ಮ ಮನೆಯಲ್ಲಿದ್ದೆ. ಈ ರೀತಿಯಾಗಿದೆ ಎಂದು ಚಾಸ 6 ಎಲ್ಲವ ನನಗೆ ಹೇಳಿದ್ದರು. ಆಗ ನಾನು ಆರೋಪಿಯ ಮನೆಗೆ ಹೋದೆ. ಆರೋಪಿಯ ಮನೆ ಗೊಲ್ಲಾರ್ ಕೋಣೆಯಲ್ಲಿ ಇರುವ ಪತ್ರಾಸ್ ಮನೆ. ಅಲ್ಲಿ ನಾನು ಹೋಗಿ ನೋಡಿದ ಶ್ರೀದೇವಿ ಸತ್ತು ಬಿದ್ದಿದ್ದಳು. ಅವಳ ಕುತ್ತಿಗೆ ಗಾಯ ಆಗಿತ್ತು. ಆಗ ಶ್ರೀದೇವಿ ಅಪ್ಪನಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದೆವು. ನಂತರ ನನ್ನ ತಾಯಿ ಚಾಸ 1 ಎಲ್ಲವ 7 ಬಂದು ಕಚೇರಿಗೆ ಹೋದಳು. ಆ ದಿನ ಶ್ರೀದೇವಿಯ ಮೈ ಮೇಲಿದ್ದ ಬಟ್ಟೆಗಳನ್ನು ನೋಡಿದರೆ ಗುರುತಿಸುತ್ತೇನೆ.
Who is this LO CW6?
CW6 is a labor millards.
Whether she examined?
PW6.
Huh?
PW6.
What is our evidence?
Yes, on hostile millards.
Hostile, huh?
Yes, millards. Page 66 are evidence. Page 66, CW6.
What about the death with the postmortem PM conducted by doctor?
The Dr. Millard's page 29 is the.
What is the cause of death?
Ligature on the death was due to asphyxia as a result of strangulation by ligature. Page 31. Death due to asphyxia as a result of strangulation by ligature.
So ligature is antemortem in nature, huh?
Yes. How?
An antemortem ligature.
Antemortem ligature. But 31.
What is your defense?
Lord, the defense taken is that I was not at all present in the village on the date of incident. Plea of alibi is taken.
Is it sufficient? You being a husband?
It is not. It is a case for 304B, Millards, that would happen, but it is a case of 302. The chain of circumstances has to be fully established.
Why?
The recovery is not established.
The
witness-
death caused in your house.
Yes, yes,
matrimonial
Millards.
home.
I ought to explain that, but that is not done. Only alibi is set up, Millards. That is the only.
If you have not committed the incident, who else has committed? You are
That-
the husband, your husband, none else than the husband.
Yes.
So duty bound on you, duty cast on you, you have to explain. Explain, I.
That is not done. Only alibi defense is taken.
106.
Yes.
If you fail to discharge the burden under 106, then the court can presume presumption under 114. 114 of evidence act. That is sufficient.
True.
Hmm.
Except the plea of alibi, nothing is done.
Hmm. Recovery proved, whether recovery proved,
No, Millards, the punches to the recovery have been,
where?
they have turned hostile, Millards. The witness to the Panchnama have turned hostile.
Was in the place, huh?
Yes, it was in the house. Yes, Millards.
Those panchas are turned hostile.
Yes, they have turned hostile.
The season under separate season was or spot mass? ಯಾವ್ದ್ರಲ್ಲಿ ಸೀಸ್ ಆದದ್ದು?
Exhibit B.
ಎಮ್ಮು ಎಷ್ಟದು?
MO, Millards,
Whether doctor gave such opinion that could be injury could be caused due to the ಹೇಳಿದಾರ? By that wire ಅಂತ.
that,
Evidence, doctor evidence ಓದಿ ಒಮ್ಮೆ.
yes,
Come to doctor's evidence. PW 15, huh?
EW 15.
What is your suggestion to the witness? ಏನ್ ಹೇಳಿದ್ದೀರಿ cross ಅಲ್ಲಿ?
Nothing.
ಏನಿಲ್ಲ.
Page 93 is the cross examination. May I read, my lords? ಸಾಮಾನ್ಯವಾಗಿ ಬೇರೆ ವೈರ್ನಿಂದಲೂ ಕುತ್ತಿಗೆ ಸುತ್ತಿ ಜಗಿದರೆ ಮೇಲ್ಕಂಡ ಗಾಯಗಳು ಆಗಬಹುದು ಎಂದರೆ ಸರಿ. ಸಾಯುವ ವ್ಯಕ್ತಿ ತಾನೇ ಸ್ವತಃ ವೈರ್ನಿಂದ ತನ್ನ ಕುತ್ತಿಗೆ ಬಿಗಿದುಕೊಂಡು ಎಳೆದರೆ ಈ ರೀತಿ ಗಾಯಗಳಾಗಬಹುದು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಮೃತಳ ಮರಣೋತ್ತರ ಪರೀಕ್ಷೆ ಮಾಡಿದ ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದೇನೆ ಸರಿಯಲ್ಲ. ಪೊಲೀಸರಿಗೆ ಅನುಕೂಲ ಮಾಡಕ್ಕೆ ಸುಳ್ಳು PM ವರದಿಯನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ.
ಸಾಯುವ ವ್ಯಕ್ತಿ ತಾನೇ ಸ್ವತಃ ಬೇರೆ ವೈರಿನಿಂದ
They have admitted that this plastic wire has been used for the commission of this offense.
That's all, Rajesh, ಅಷ್ಟೇನಾ? SPP?
Yes.
ಹೇಳ್ತೀರಿ ನೀವು.
Well, it's admittedly this is a homicidal death. The death has been occurred in the house of the appellant. He has to, he being a husband, even he did not know the complaint. And of course, my lord, some material witness like Pancha, they can, but that doesn't mean that the entire prosecution case has been discarded. And IO has categorically stated what has been recorded and where it has been kept. The material, that is plastic wire, which has been used for the commission of an offense, my lords. It has been kept in
Now,
the.
what is the difference of homicide, strangulation and suicide?
Well, strangulation is different, that different of that is strangulation is different, my lords. But this strangulation and he.
We'll continue. 230. Please.
Serial number 36, Lordship. Serial number 36, Lordship. 36.
36.
Lordship. In this appeal, Lordship, we have engaged the senior counsel, Lordship. Lordship, he lost the father, Lordship, few days back, Lordship. Kindly one date to be decided, Lordship, after 20th.
No, we have said first 10 matters will not be adjourned, will not be adjourned.
Lordship, it's 2020 matter, Lordship. Criminal appeal, Lordship.
No, he's in custody. It's 9 years.
Lordship, in this matter, Lordship, we have engaged the senior counsel, Lordship.
No, that is not the reason at all.
Please.
You say tomorrow, day after tomorrow, Monday, like that, within a week, not beyond. Otherwise, we'll have it after 5 years. Your choice. You think, can you make it?
Lordship, I will take the instructions, Lordship. Please.
Modification.
Number
My lord.
31.
Serial number 16.
Ah.
I have to file second set, my lord, earlier.
We'll have it next week.
Yes, next week, short accommodation, I'll file.
Next week, date.
Serial number 16, my lord.
You file it.
Yes, ma'am.
So we'll take it up on that day and we'll dispose it.
Earlier it was before the honorable single judge, ma'am.
Correct.
Yes,
Second set we filed.
yes, ma'am. Within
The
2, 3
appeals
days, I'll
filed
file.
by the
Yes,
insurer. Relist on 16.
yes.
31.
Madam.
Week after next.
Date may be given,
Date
long, short date.
23rd.
Serial number 43, my lord. After 15th, any date.
40.
43. After 15th, any date, my lord. One date will be fixed.
Synopsis is filed.
2000, please, my lord.
Synopsis you already filed.
File, my lord. One date may fix, I will.
This next week. date.
One date.
Next week, yes. Next week date.
ರೆಡಿ ಇದ್ದೀನಿ ನಾನು ಅಡೆ ಬಿಡ್ತಾ ಒಮ್ಮೆ ಹೋದ್ರೆ ಮುಗ್ಸೋದ್ ಚಲೋ ಏನ್ ಹೇಳಂದ್ರಿ
Court officer, sir.
ಹೇಳಿ ಮೇಡಮ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಏನಾಯ್ತು?
17th ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್.
ಮೇಡಮ್ ಇದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಕ ತಗೊಳಲ್ಲ ಮತ್ತೆ?
ಇಲ್ಲ ಮೇಡಮ್, ಎರಡು ಸೈಡ್ ಕೇಳ್ಬಿಟ್ಟು 17th ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಮೇಡಮ್.
ಹೌದಾ ಮ್ಯಾಮ್? ಓಕೆ ಮ್ಯಾಮ್, ನೋಡ್ತೀನಿ ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Till number 7, Ramachandra K.
Your lordship is asked that deputy commissioner order, my lord. Kindly see, this is the order.
No representation on behalf of the complainant. Relist the matter tomorrow.
Please.
AGA submits that consideration is complete.
Yes.
Nale will dispose it of.
Taslar is not present.
Huh?
Our officer need not be present tomorrow.
ಇಲ್ಲ ಪರವಾಗಿ not
Please.
not.
Great.
Till number 56, VK Hireman, Shivanand Patil for respondent.
Relist. Putting date. Okay.
Number 24, Sandeep Vijay Kumar Patil.
I appear for the respondents, your lordships. In this matter, there is some sort of compromise that have been done, your lordship. The appellants have to state that.
Settlement.
Yes, your lordship.
We'll have it tomorrow.
That they have to tell your lordship.
Day after, sir.
Yes,
We'll have it day after tomorrow. Let them come. Let us
please.
relist. Day after tomorrow. Okay.
Great.
Till number 35, Rajesh. Rajesh Tudman.
What is the accused occupation? What was he? Is?
What is the reasoning of the trial judge? Jurisprudence ನೋಡಿದ್ರಾ?
Yes, my lords.
What is the difference? ಏನೇನ್?
Shall I read? Against me, then also I have to read, my lords.
Now, before that,
There must, for the presumption under 106 to apply,
Yes, my lords.
prosecution must place material,
Yes,
isn't it?
yes.
Now, is there any evidence that he was there in the house?
No, sir. Only that lady, the PW 6, my lords, she has not supported the case of the prosecution.
Because what one doubt is in our
Yes.
mind,
Yes,
for presumption under 106 to apply,
yes,
there must be some material to discharge the burden of the prosecution.
yes.
So whether he was there in the house on that day,
That is not there, my lords. The only contention of the prosecution is that, my lords, the death is homicidal and occurred in his house only. He being a husband of that particular deceased, my lords, he would have lost the complaint and he absconded from.
what is he?
He's a coolie man. Coolie. Labor.
No, we are only just saying to here hypothetically, let's assume
Yes.
that he was not there, though they have not shown that. Suppose he was working as a driver, used to be to 1 day, 2 day outside, etc. So from that point of view, we just want to know if there's any evidence to show that he was there in the house.
But that is not there, my lords, but he was not a driver and all those things. They were residing both regularly in that particular house itself, my lords. And also, my lords, even they haven't elicited the material that to the effect that, my lords,
He was not there.
yes. That is not the cross-examination. Even in the cross-examination, nothing has been elicited, my lords, to that effect. If that has been brought, the thing would have been different.
what is it? 313? 313 ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
313 ನಲ್ಲೂ ಏನೂ ಇಲ್ಲ ಸರ್.
Just denied, huh?
Denials. Only denial.
No defense evidence.
No, sir.
Huh?
No, sir.
So what is the suggestion at least?
ಯಾರೋ ಹೊಡೆದು
Suggestion to the witnesses.
ಯಾರೋ ಹೊಡೆದು ಹೋಗಿದ್ದಾರೆ.
Huh?
Nothing, no suggestion at all.
ಮತ್ತೆ? ಅಲ್ಲ PW1 ಗೆ ಏನಾದ್ರು ಕೇಳಿದ್ದೀರಾ ಏನಂತ ಹೆಂಗೆ ಸತ್ರ ಅಂತ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಸವಾಲ್ ಇಲ್ವಾ?
ಪಾರ್ಟಿ ಸವಾಲು ಇದೆ ಸರ್. ಪೇಜ್ ನಂಬರ್ 50.
ಪೇಜ್ ನಂಬರ್
50 ಪೇಪರ್ ಬುಕ್.
ಹೊರಟು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಯಾರೋ ಹೊಡೆದು ಹೊರಟು ಹೋಗಿದ್ದಾರೆ
ಅಷ್ಟೇ.
ಅವನೇ ಸಾಯಿಸಿದ್ದಾನೆ, ಸುಳ್ಳು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾನೆ.
It appears to be a natural.
ಸಜೆಷನ್ ಇದೆ in para 6 ಅಲ್ಲಿ ಪೇಜ್ 6 ಅಲ್ಲಿ ಕ್ರಾಸ್ ಇದೆ ರೀ. ನೀವು ಓದಿಲ್ಲ, ರೆಡಿ ಆಗಿಲ್ಲ ರಾಜೇಶ್ ನೀವು ಕೂಡ. ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದ ಮ್ಯಾಟ್ರಿಗೂ ನೀವು ರೆಡಿ ಆಗದಿದ್ರೆ ಹೇಗೆ? Now SVP, you just show
My lords.
the evidence of any of the witnesses. The accused and deceased were in that house on that day, as my lord said.
Yes. PW 8 and 9, my lords.
Huh?
PW 8 and 9.
ಬನ್ನಿ, ಎಲ್ಲಿದೆ evidence? ಆ ದಿವಸ ಮನೆಯಲ್ಲಿ ಇದ್ರು ಅಂತ. ಆ ದಿವಸ ಆರೋಪಿ
ಅವ್ರಿಗೆ
ಮನೆಯಲ್ಲಿ
ಹೇಳಿದ್ರು ಅಂತ ಅಷ್ಟೇ ಅದ ಸರ್. But more particularly, they were there and gone through entire evidence, my lords. That has not come.
That is the primary burden on the prosecution.
That is there, my lords. The only thing is that to overcome 106.
See,
He
in
had
order
to-
to invoke section 106, primary burden lies to the prosecution to show that they
Yes.
both were there in the house on that day.
That is PW6, my lords. She has not supported.
It turned
Yes,
hostile.
yes,
Hmm.
that is the only.
Hmm. The reasoning of the session judge only on 106.
106. No,
Which
page,
paragraph?
page 153,
Of the judgment.
153 to. It has been elaborated in page number 165. And before that, my lords, my lords may have a glance on page number 153 of paper book. That is 34 para. In last 4 lines, my lords. 153 page number, para 34 minutes. My lords, that is PW 2, 3, 5, 6 and 7 have turned hostile. But in this case, as the death of deceased Sridevi, wife of accused, is homicide in the house of accused during intervening night of 31/5/2015 and 1/6/2015, and as only the accused and his wife were present during night on the day of incident. In such circumstances, the accused has to disclose as to how she died and who is responsible for her death. And he has to explain the same as per section 106 of the Evidence Act.
Who stated so? Who stated so?
He has to explain.
Hello, who stated so? They were in the intervening night of 31/5/2015 and 1/6/2015. The accused and wife were present during night time. Who stated so?
That is PW6.
Still PW6 support ಮಾಡಿದ್ದಾರೆ.
Yeah,
ಮತ್ತೆ?
that is there, man. That is my grievance. And even then, what session judge has opened and what he has appreciated the evidence of all the witnesses which have been adduced before this trial court, members. The accused has not at all stated anything as to who is responsible for the death of deceased Sridevi, and no explanation was stated by him while recording the 313 statement.
ಅದಕ್ಕೆ the right to remain silent.
Yes, my lords. Yes, yes.
The prosecution has to prove beyond reasonable doubt.
I do agree. I do agree.
That is the Supreme Court said that
Yes.
you must prove, must be, not maybe.
Yes, must.
Accused must be committed the offense.
Yes. That is there, my lords.
ಏನ್ ನೀವು ರೆಡಿಯಾಗಿ ಬರ್ಲಿಕ್ಕಿಲ್ವಾ? ಜಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ? ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ಹಿಂಗ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ?
ಒಂದು ಕೊಡ್ತೇವೆ. ಇದ್ರೆ ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಬಿಡಿ.
What is the medical evidence?
Medical one, yes. Yes. Strangulation, Lord says. The way death was caused by strangulation.
That
Well,
difference, ಅದು ಇದು ಹಾಕಿದಲ್ಲ ಚಾರ್ಟ್, difference between strangulation and.
ಇದೆ sir, ಇದೊಂದು definition.
ಆಯ್ತಾಯ್ತು ಹೇಳಿ.
No inference should be drawn simply from a ligature mark. For it may be indistinct or absent if a soft ligature like silk is used and may be produced by the application of ligature to the neck even after death. Similar marks may be produced by a collar or neckband worn loosely around the neck when it compresses the tissues which are swollen and distended by putrefaction. Irregularities in the fingernail marks may pinpoint a killer. That is not there.
ಬರ್ಕೊಳ್ಳಿ. Yes.
Please.
This appeal. ಇದು ರೆಕಾರ್ಡ್ ಆಗುತ್ತೆ ಇದ್ರಲ್ಲಿ ಕೊಟ್ಬಿಡ್ತೀನಿ ತೊಂದರೆ ಇಲ್ಲ, ಬೇಕಾಗಿಲ್ಲ ಬೇಕಾಗುತ್ತೆ ಆಗುತ್ತೆ ಆಗ್ತಾ ಇದೆ. This appeal by the convicted accused directed against the judgment of conviction dated 24/11/2017.
ಕೊಡಿ ಇಲ್ಲಿ ಇಟ್ಟುಕೊಳ್ತೇನೆ.
This appeal by the convicted accused directed against the judgment of conviction and order of sentence dated 24/11/2017 passed by the third additional session judge Vijayapura in SC number 17 of 2016, wherein the learned session judge has convicted the accused for the offense punishable under section 302 and 302 of IPC and sentenced the accused to undergo imprisonment for life and to pay a fine of ₹10,000 in default of payment of fine amount, directed to undergo rigorous imprisonment for a period of 6 months for the offense punishable under section 302 of IPC. Full stop. The factual matrix of the prosecution case in brief are that on 1/6/2015 at about 4 AM in the tin shed bearing Khata number 1404 belonging to one Timmanna, son of Bhimanna Golur, situated in Gollur Street, Sindagi town, the accused appellate by suspecting the fidelity of his wife, the deceased, what is her name? The
Shamalabai.
deceased Shamalabai.
Sridevi.
Deceased Sridevi, sorry, deceased Sridevi
First case.
became angry and also as she did not pay money to him for his bad vices, with an intention to commit her murder, put the plastic wire bracket and Bombay Ghat bracket close as nose around neck of his wife and tightly pulled the wire and smoothed and thereby committed her murder. and committed a murder, full stop. Thereafter, murder, and thereafter fled away from the spot, full stop. They subsequently, PW1 being the grandmother of the deceased Sridevi, lodged the complaint before the respondent police, that is the CPI Sindagi Circle, as per Exhibit P1, and based on the same, the respondent police registered the FIR against the accused for the offense 302 of IPC in crime number 146 of 2015, dated 1/6/2015, as per Exhibit P17. Full stop. Later, the investigation officer, that is PW18 conducted the investigation, by drawing the spot mahazar and conducting the inquest panchanama on the dead body of the deceased as per Exhibit P4 and Exhibit P10 respectively, and apprehended the accused on the next day, 2/6, that is on 2/6/2015, full stop. Based on the voluntary statement of the accused, the investigation officer recovered the clothes of the accused, which worn at the time of the incident. So also the material object MO 124, MO1, MO5, that is the plastic wire which said to have used for the commission of the crime. Subsequently, after obtaining necessary documents from the concerned authority, PW18 laid the charge sheet against the accused for the offense punishable under section 302 of IPC before the committal court. Full stop. Next. After committal of the case before the session court, the learned session judge, by securing the presence of the accused, framed the charge for the offense punishable under section 302 of IPC, and read over the same to him. Full stop. However, the accused denied the charges and claimed to be tried. Full stop. In order to prove the charges leveled against the accused, the prosecution in total examined 18 witnesses as PW1 to PW18. So also got marked 24 exhibits as exhibit P1 to P24, and got identified 5 material objects MO125. Full stop. Next. After assessment of the oral and documentary evidence, the learned session judge convicted the accused for the offense as charged and sentenced him as stated supra. Full stop. The said judgment is challenged under this appeal. Next, we have heard the learned counsel, Shri Rajesh Doddamani, for the appellant accused. So also the learned additional SPP for the state. Full stop. The primary contention of the learned counsel for the appellant that the judgment under this appeal suffers from perversity and illegality, since the learned session judge has failed to appreciate the entire evidence on record in a right perspective. Full stop. According to the counsel, all the material witness examined by the prosecution to prove the charges leveled against the accused are turned hostile in spite of that, the learned session judge has convicted the accused only based on the surmise and conjecture. Full stop. The conjecture. Though full stop. Though the according to him, though the prosecution has proved the homicidal death of the deceased by way of strangulation, comma, to connect the accused for the said death of the deceased, comma, absolutely no connective evidence. Absolutely, there is no material evidence placed by the prosecution. Full stop. The prosecution. The complainant, being the grandmother of the deceased, is a hearsay witness, and the other material witness, that is PW6, before whom the accused allegedly made the extrajudicial confession, has also turned hostile. The further PW8 and PW9 was the main circumstantial witness, comma, and the relative of the deceased are also turned hostile to the prosecution case. Nevertheless, the prosecution also failed to prove the other circumstances like recovery of the material object which is said to have used for the commission of the crime by the accused. As such, according to the learned counsel, comma, according to the learned counsel, comma, it is the prosecution has to prove its case beyond reasonable doubt by placing a cogent evidence. However, in the case on hand, there is no such believable evidence placed by the prosecution. Full stop. Hence, he prays to allow the appeal by setting aside the impugned judgment of conviction and order of sentence. Full stop. Per contra, the learned SPP for the state would contend that the judgment under this appeal does not suffer from any perversity or illegality, since the learned session judge has meticulously examined the evidence on record and passed a well-reasoned judgment which does not call for any interference. According to the learned SPP, the deceased is none other than the wife of the accused, and they both were residing in the rented house at
Chindagi.
At
Chindagi Gollaroni.
Gollaroni at Sindagi Taluk, and as such, burden lies on the accused. Lies on the accused to show that the reason for the cause of the cause for the death of the deceased. Full stop. According to him, by the evidence of PW1, PW7, and PW8, and 9, PW7 to 9, the prosecution has successfully proved that the accused and the deceased were residing together, and on the date of incident, the accused was very much present in the house house. As such, if he fails to give any such explanation for the death of the deceased, then as per section 106 of Indian Evidence Act, the court can presume, court can draw a presumption under section 114 of the Indian Evidence Act. Full stop. Nevertheless, the other witnesses examined by the prosecution, that is the family members PW1, PW7 to 9 also deposed, 7 to 9 deposed that deposed about the ill treatment given by the accused to the deceased by suspecting her fidelity, so also by demanding money for his bad vices. Bad voice. In such circumstance, comma, the prosecution has successfully established the guilt of the accused beyond all reasonable doubt. Full stop. Moreover, the investigation officer PW 18 also deposed similarly to that of the evidence of PW 1, PW 721 and PW 729. PW 729. In such circumstance, comma, the learned SPP
Doctor PW 15.
729. Full stop. You would also contend that the oral testimony of PW 1 PW1 clearly corroborates to the medical evidence of PW 15 that the death was caused due to homicidal strangulation, full stop, by way of smothering, full stop. In such circumstance, comma, the prosecution has proved the guilt of the accused beyond reasonable doubt, and the learned session judge has rightly convicted the accused for the charges leveled against him. Accordingly, praised to dismiss the appeal. Full stop. Next. Having heard the learned counsel for the respective parties, so also perusal of the entire evidence on record, including the impugned judgment, comma, the points that would arise for our consideration are: number one, whether the judgment under this appeal suffers from any perversity or illegality. Number two, whether the learned session judge is justified in convicting the accused for the offense 30205 PC. Next, in this case, though the prosecution has examined 18 witnesses to prove the charges leveled against the accused, it is not necessary as to discuss the evidence of all the witnesses. Suffice to reappreciate the evidence of the material witnesses examined by the prosecution. Full stop. In order to prove the homicidal death of the deceased Sridevi in this case, the prosecution has the prosecution has mainly relied on the evidence of PW 15, the doctor who has conducted the autopsy of the dead body of the deceased and issued the postmortem report as per Exhibit P.
18 minutes.
Exhibit P18. For Exhibit P18. So also the evidence, the inquest Panchanama conducted on the dead body of the deceased by PW 18 investigation officer as per Exhibit P10. Full stop. On careful perusal of the contents of Exhibit P18, that is the postmortem report, the doctor has given the opinion. The doctor has given the opinion as to cause of death is the death was due to asphyxia as a result of strangulation by ligature. Further, he has also stated that the ligatures are an antemortem ligature mark is found on the neck of the deceased Sridevi. Full stop. Sridevi. Full stop. To further to substantiate that aspect, the PW 3, PW 4 and PW 5 were the witness for inquest Panchanama drawn on the dead body of the deceased as per Exhibit P10, state similarly stated that there is a ligature mark found on the neck of the deceased. Full stop. Hence, a conjoint reading of the evidence of PW 15, the doctor and the evidence of PW 4, PW 5 and the PW 18, the investigation officer, along with the report of, along with the post-mortem report of the doctor, that is exhibit P18 and inquest Panchanama, exhibit P10, comma, we are of the considered view that the prosecution has proved the homicidal death of the deceased beyond all reasonable doubt, that beyond reasonable doubt. Next part. In order to connect the accused for the homicidal death of the deceased in this case, comma, the prosecution has relied the evidence of PW1, that is the grandmother of the deceased, who has set the criminal law into motion by lodging the complaint, that is exhibit P1. On perusal of exhibit P1, the complaint, comma, it is stated that the deceased Sridevi was given in marriage to the accused at about 8 years prior to the date of incident. Full stop. Thereafter, they both were residing in a tin shed at Sindagi Taluku, Gollara Oni. Full stop.
Sindagi town itself.
Gollara Oni. Though it is stated in the complaint that the accused stated that the relationship between the accused and the deceased was strained one, and the accused used to give mental and physical torture to the deceased by suspecting her fidelity, so also for demanding money from her for the bad vices. However, bad vices, and to that effect, based on the complaint of the deceased, she visited the house of the accused and advised him not to indulge in such activities. However, on 1/6/2015, the PW9, the son-in-law of her son-in-law, has informed her that the accused informed her that the accused was committed the murder of the deceased by way of strangulation. Thereby, they herself, PW10, and the other relatives of PW1 rushed to the house of the deceased and found the dead body of the deceased in the house. Full stop. In the house. According to PW1, on the in the place of incident, that is in the house of the deceased, on inquiry with the PW8, that is one Sunita, she came to know that the accused is the reason behind the incident. Full stop. In the incident, on perusal of the evidence of PW1, she reiterated the awareness of her complaint as per exhibit P1, and also stated that she came to know about the incident, that the accused was the perpetrator of the crime through PW9. Full stop. On perusal of the evidence of PW9, one Rama Byakoda, who is also the relative of the deceased Sridevi, he has stated that 2 years prior to he has stated that on the stated that he was informed by some some of the residents of the said colony where the accused and deceased were residing about the incident. Full stop. incident. Further, the PW8, that is none other than the wife of PW9, also stated similarly that also deposed that one Yellava was PW1.
6.
PW6.
Six.
One Yellava, that is
Both
PW6. PW6 has informed her about the
Yes.
about the incident. Interestingly, both these witnesses, that is PW8 and 9, being the close relative of the deceased, have partly turned hostile to the prosecution case. First off, coming to the evidence of PW6, who allegedly informed the incident to PW8, as stated by her, the PW6 totally turned hostile to the prosecution case, and she has denied the said aspect in her evidence. Though the learned public prosecutor made an cross-examined her at length on that aspect, nothing worthwhile has elicited on her from her
Evidence.
in order to prove that she has given the information about the death of the deceased to PW8. Full stop. PW8. As such, PW8. Further, it is also the case of the prosecution that the accused allegedly confessed his act before PW6. Full stop. So as far as that portion of the evidence is concerned, PW once again turned hostile to the PW6 also turned hostile to the prosecution case. Hence, as far as the extrajudicial confession made by the accused is concerned, there is absolutely no evidence placed by the prosecution before the trial court. Full stop. On a careful perusal of the evidence of PW6, PW8 and PW9, along with the evidence of PW1, all these witnesses have categorically, all these witnesses have failed to state that who had informed them about the alleged incident, So also on the aspect that the accused and the deceased both stayed together on the intervening night of 31/5/2015 and 1/6/2015. 1/6/2015. Full stop. 15. Full stop. Further, 1/6/2015. Full stop. It is full stop. The learned SPP vehemently contended that since the incident was caused in the house of deceased and accused in the rented house, of the deceased and accused, and the accused being the husband of the deceased, is duty bound to explain under what circumstance the death of the deceased was caused. Full stop. As per the provisions of under section 106 of Indian Evidence Act. Full stop. No doubt, by Indian Evidence Act. Full stop. No doubt, the accused being the husband of the deceased is duty bound to explain the said circumstance. However, it is settled law. It is settled law by this court and by the Honorable Apex Court that before discharging such burden by the accused, it is the duty of the prosecution. Primarily, it is the duty of the prosecution to prove that the accused to prove by placing cogent evidence that the accused was in the company of the deceased on the date of incident in the house, as discussed supra, on perusal of the entire evidence of this, the material witness, there is no such evidence forthcoming in the forthcoming that the accused was in the accused was in the company of the deceased on the date of incident, on the date of incident. Moreover, date of incident, full stop. Moreover, it is the defense of the accused that moreover, the accused was taken a plea of a levy that he was not staying at Sindagi, and on the date of incident he was at Gubbewada, a different taluka. Gubbewada, Gubbewada town, full stop. Gubbewada town, full stop. In such circumstance, it is the such circumstance, it is the duty cast on the prosecution to prove the act of the accused by relying on the other circumstance. Admittedly, when the case is rests on circumstantial evidence, the prosecution has to prove the circumstance, each circumstance without any break of the chain, without the break of chain link. Full stop. In the case on hand, except the homicidal death of the deceased by way of strangulation, the other circumstance that is the recovery of the weapon which said to have used for the commission of the crime under Exhibit P5 and Exhibit P5 and P6, P5 and P6, the 6 also not proved, since the witness for the same, that is PW 2 and 3, 3 and 4, 4 inquest alva. 4. 2 and 3. PW 2 and 3. PW 2 and 3 have turned hostile to the prosecution case. The other circumstantial witness, that is PW 8 to PW 10, also turned hostile to the prosecution, also turned hostile to the prosecution case.
No, they are support.
It's partly turned, PW 8, 9.
8, 9. But
PW 10.
10 and 11 they are supported.
They are also partly supported. PW 10 no evidence. Just see the evidence of PW 10. Just a minute.
The complaint son, my lords, supported.
8 and 9.
8 and 9,
sir. 8 and 9. PW 8 and 9 partly turned hostile.
Yes.
PW 8 and 9 partly turned hostile. Full stop. Partly turned hostile. They
10 and 11 fully support.
Yeah, turned hostile. Full stop. Though PW 10 and 11 supported the case of the
11 is a scriberman.
Supported the case of the prosecution. PW 11 is the scribe of the complaint, exhibit P1, exhibit P1.
Yes.
And PW 10 being the another circumstantial witness, also stated that I was informed by some other person in respect of the act committed by the accused, PW informed by PW 8 and 9. 8 and 9 about the act committed by the accused. As such, he has to, the evidence of PW 10 has to be considered as a considered as a hearsay evidence, full stop. It is a settled principle of law that the much credence cannot be given to the evidence of a hearsay witness without any such a corroborative piece of evidence. As far as the contention issued by the learned SPP in respect of the presumption under section 106 of Indian Evidence Act is concerned, the Honorable Apex Court in the case of Jaikam Khan versus State of UP reported in 2021 volume 6 2021 volume 13 SCC 716 madam. 716 in paragraph 73 of the paragraph 73 comma it is 73. It is stated that madam 73 and Akoli. full ಹಾಕೊಂಡು ಕೆಳಗಡೆ ಅದು emphasis supplied me pass ಅಂತ ಹಾಕೊಳ್ಳಿ. Hence ಕೆಳಗಡೆ ಮತ್ತೆ hence in view of the settled norms, the burden of proving the special knowledge cannot be shifted on the accused merely on the basis of factum of place of occurrence, unless the prosecution has proved its case beyond all reasonable doubt. They, as stated supra, the contention of the learned additional SPP would not be of much avail to the prosecution case, as they have felt defects in proving the guilt of the accused beyond reasonable doubt. Full stop. Reasonable doubt. Say reasonable doubt. Full stop. It is the prosecution has to prove the case beyond reasonable doubt. The Honorable Apex Court, the Honorable Apex Court in the case of Honorable Apex Court in the case of Honorable Apex Court in the case of Nagendra Singh and another was the state of MP reported in 2004, volume 10 SEC 699 held that the prosecution has to prove its case beyond reasonable doubt, and there is a distance between the place of proof maybe and must be full stop. They must be full stop. They must be in the case on hand on careful perusal of the entire evidence on record, it could be entire evidence record, it could be gathered that the learned session judge has convicted the accused solely based on the aspect that the accused and deceased were residing together, and the accused failed to discharge a burden under section 106 of Indian Evidence Act. However, as per the judgment stated supra, we are unable to accept the reasoning of the learned session judge. Full stop. The session judge. The Honorable Apex Court in the judgment referred in the case of Mosam Singh Roy and others versus state of West Bengal has made an observation that in respect of moral conviction, A bordering on strong suspicion is not an option to decide a case by the trial court and held in paragraph 27 as under, Akoli, paragraph 27 as under, full stop, as under, in the case on hand, though there is a short of evidence to prove the charges leveled against the accused, the learned session judge has convicted the accused, based on surmise and conjecture, which in our view, the said conviction order cannot be sustained, full stop, sustained, sustained, full stop. In view of the above discussion, in that view of the matter, we are of the view that interference is required in the impugned judgment of conviction and order of sentence. Accordingly, we answer the point number 1 in the affirmative and point number 2 in the negative, and proceed to pass the following order. Full stop. The judge, the criminal appeal number 200-209 of 2022 is allowed. Next part, the judgment of sentence and order of conviction passed in SC number 17 of 2016, dated 24/11/2017 by the third additional session judge Vijayapura is hereby set aside. The accused appellant is acquitted for the charges charges leveled against him, that is for the offense punishable under section 302 of IPC. Full stop. The 302 of IPC. Is in custody, 302 of IPC. The jail authorities, the concerned jail authorities are directed to certainly but the accused, directed to release the accused forthwith if he is not required in any other cases. Registry is directed to send the operative portion of this order, to the concerned jail authority for the necessary action.
Number 36, Ganesh Nayak.
That Aruna Sham Lordship, his father is demised Lordship few days back. He personally wants to appear to before the Kalabur. Please, Lordship. His father demised a few days before Lordship. He requested to take time, Lordship. After 19, Lordship, any date to be fixed.
It will be in the list. Let us see. We'll take the others. It will be in the list.
Please, Lordship.
We'll take other matters, but get ready in the meanwhile.
Much obliged.
Number 37, Girish Yampati.
I appear for the appellant in this case, my lord. Firstly, I'd like to seek an adjournment because my lord, this is a case where the nature of a life imprisonment has been set, but till the end of life, my lord. And I have furnished all the citations and everything. Hence, I want to appear physically before my lords on any date if my lords permit me to appear and argue the matter on acquittal, my lords.
When will you appear?
After 19th, any date if my lord permit.
We are having this day to day. We are not giving time like that. We are having day to day matters, criminal matters.
Okay, in that light, my lords, kindly my lords may have it on 16th or 17th of next week, my lord, at 2:30 p.m. Please.
You can't give like that. It will be in the list. Let's see. Next notice.
And my lord, and and one more submission, my lord. In another some connected case of the same judgment, my lord.
What is your submission?
In another judgment, my lord, a criminal appeal number 20086 of 19, my lord. 200 of 86, criminal appeal number 200 of 86. The same award has been also been awarded in this judgment also, my lord. Kindly the same matter may also be 20086 of 2019, my lords. Kindly this matter may also be tagged with this matter. Please. But life imprisonment till death has been awarded in this appeal also.
So that question we will decide. It's a question of law that we'll decide. You get ready on the merits. Yes, next.
Yes.
Shambhulinga Kalimat,
Yes.
38 Shambhulinga Salimat,
Next.
number 39 BC Jaka,
ಅಲ್ಲ ಅವ್ರೇನು
As a lot of direct start if they are not. I'm ready, man. Preamble permit me and start. Let the firm answer.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ತಂದೆ ಏನೋ ತೀರೋಗಿದ್ದಾರೆ 19th ಆದ್ಮೇಲೆ ಅಂತಿದ್ದಾರೆ ಗ್ಯಾಪ್ ಆಗುತ್ತೆ. ಇಲ್ಲ ವಾಟ್ ವಿಲ್ ಡೂ, ನಾಳೆ ಇನ್ನೂ ಒಂದು 5 ಸೇರ್ಸೋಣ. ಯಾಕಂದ್ರೆ ಈ ಒಂದೆರಡು it's going to two, three of these matters. Let it be in the list, but it looks like after another 10 days. So ನಾಳೆಯಿಂದ ಇನ್ನೂ ಒಂದು 5 ಸೇರ್ಸೋದು. ಜಾಕ ಇಲ್ವಾ ಇದ್ರ ಒಂದ್ಸತಿ ಫೋನ್ ಮಾಡಿ ನೋಡಿ ನೀವು. ಒಂದ್ಸತಿ ಫೋನ್ 40,000.
40 Sachin Emma,
36 or ಬರ್ಬೇಕಮ್ಮ 19 months.
ನೋಡಿ. So we'll keep it in the list, but because of this, we'll put another 5 matters in tomorrow's list. We'll ask them to put in the 5 matters advance list. 40,000.
40 Sachin Mahajan, Shivanand Pati, correspondent.
Ready, right?
Tomorrow, my matter is there in single bench, madam. Next, madam.
Tomorrow now, nimbit ಬೇರೆ ಯಾವ ಕೇಸ್ ಹಾಕಲ್ಲ. Huh?
I see.
Because we don't want to, so tomorrow means tomorrow.
Yes.
Yes.
All the submissions are almost addressed, my lord, a couple of minutes more.
Yes.
My lord may kindly bear with me. Section 8, my lord, I was referring to. I'm not scheduled to section 8. My lord, there is mention of son. It does not make any distinction between legitimate or illegitimate. What it says, my lord, is son.
So that position has been settled now.
My lord,
Succession of legitimate.
now, he being, my lord, the sole surviving heir.
No, correct. Now, that is the very issue that is in dispute. You are saying which will consider. According to you, since the father.
Even if, my lord, even if, my lord, the court may, if ultimately, my lord, my submission is that this, my lord, again is an off the record submission. With all constraints, my lord, I am submitting. Even if, my lord, the court comes to the conclusion regarding, my lord, the relationship of Parvatama, my lord, and the other person. Fact that he is son, once that is acknowledged, then, my lord, he becomes whether legitimate or illegitimate, it does not section 8 and, my lord, the schedule to section 8. It does not make any distinction, it does not draw any distinction between legitimate or illegitimate.
Will consider.
Yes. My lord, the nature of admission, whether it binds, my lord, the defendants herein. The admission made, my lord, by deceased Rachana in the written statement that he has filed, what effect it has, my lord, on the present defendants who are admittedly claiming their rights through the deceased Rachana. In that regard, my lord, I am relying on, my lord, section 17 and 18, my lord, of the Evidence Act, 18 more particularly. My lord.
Yes.
Admission by party to proceedings or his agents. Thereafter, my lord, after paragraph, my lord, by suitors in respective character, admele, statements made by. My lord, statements made by, I'll straight away go to 2, my lord. Statements made by persons from whom the parties to the suit have derived their interest in the subject matter of the suit are admissions if they are made during the continuance of the interest of the persons making these statements. So a statement which is made by Rachana during that time, my lord, when he had a subsisting right over the property, it will be binding on those persons who are deriving or claiming or, my lord, trying to assert their rights through him. So it cannot be a situation where, my lord, a liberty, my lord, is available for them, or there is a window for them to get away from the admission made by deceased Rachana. Admission which is made, my lord, that particular judgment of the apex court, my lord, it says, my lord, it stands on a higher footing because it's an admission made in the form of a written statement, in the form of a pleadings. So once that is there, once there is an admission, an established admission, then, my lord, what would be the consequence of such admission on the persons who are now trying to assert their rights or now who are claiming their rights through Rachana? Because their case is clear. Rachana was the owner of the property, we being the class 2 heirs, they are deriving their rights from Rachana. So my respectful submission, my lord, this particular provision, my lord, of section 18, it says, my lord, if I may read again, my lord, statements made by persons from whom the parties to the suit have derived their interest in the subject matter of the suit are admissions if they are made during the continuance of the interest of the persons making the statements.
just tell us one thing.
My lord.
The admission, section 18 or section 58 or the para 27 of your judgment, whether those admissions are only attracts only against your father's admission or admission made by you also. What about your admission in the suit?
My admission, my lord, in the suit, my lord, I would, my lord, again reiterate my statement that insofar as this dispute is concerned, insofar as this list is concerned, so far as this claim is concerned, I am, my lord, yes, your lordship, my lord, is, yes, yes. Your lordship, my lord, is referring to that situation. Yes. Your lordship, my lord, is rightly referring to that awkward situation of my part, the other part of, my lord, my story, where there is, my lord, this whole muck regarding my relationship of my mother, Chanbasappa and all that. But, my lord, I beg to submit this, that I can safely draw a distinction because I am claiming my right to through disease. The deceased has admitted me as his son. So vis-a-vis me and my father, my lord, there is an admission, an acknowledgement of the fact, an acceptance of the fact that I am his son. Now, in this situation, in this scenario, in this, my lord, whole circle, once my father, who was admittedly the owner of the property, wholeheartedly, without any duress or pressure, admits at an undisputed point of time, not only in that suit, my lord, if the totality of the material is to be taken into consideration, transfer, my lord, of vehicles is there. There are so many other documents. All this, my lord, goes to show that
We'll consider.
he has accepted me as his son. And, my lord, whether this position can be unsettled, my lord, by the defendants, whether they can question this. Probably, my lord, section 115 will, my lord, come to my aid regarding, my lord, estoppel. Estoppel, 115. When one person has, by his declaration, this, my lord, my lord, in the beginning itself, I will submit, my lord, this is a double-edged sword which will probably cut me also. But as again, my lord, trying to draw a line, confining my claim, my lord, that this is the property of Chanbasappa, my lord, I'm taking, my lord, I'm grateful, my lord, the court has been, my lord. When one person, by his declaration, act, or omission, intentionally caused, permitted another person to believe a thing to be true and act upon such belief, neither he nor his representative shall be allowed in any suit proceeding between himself and as such person or his representative to deny the truth of that thing. So, my lord, cost of repetition, my lord, I do not wish to. The defendants, who in the capacity, my lord, of representatives in the form of class 2 heirs, they are, my lord, stopped from getting away from that admission given by the deceased Rachan. And with regard to, my lord, the position of law, my lord, which I submitting yesterday, there was one judgment, my lord, of 2018 also reiterating the very same, my lord, the contents of the judgment of 1974, paragraph number 27, my lord. This is only to, my lord, the very same principle has been, my lord, followed in 2018 also. Paragraph number 27, my lord. What is the status of admissions made? Paragraph 27. Last. The last page, my lord. The last page, my lord. From the conspectus of the cases cited at the bar, my lord, it is the same, my lord, which is the principle that the emerges is that somewhere in the middle, my lord, admissions, if true and clear, are by far the best proof of facts admitted. Admissions in pleadings or judicial admissions admissible under section 58 of the Evidence Act made by the parties or their agents at or before the hearing of the case stand on a higher footing than evidentiary admissions. The former class of admissions are fully so on and so. It's a reiteration, my lord, of what is, my lord, held in the 1974 judgment.
Yes.
So my respectful submission, my lord, in a given situation where, my lord, I am able to, my lord, establish by placing, my lord, sufficient material on record that there is a relationship between me and my father, especially, my lord, in light of the fact that there is an application for additional evidence, for which, my lord, I have given sufficient, my lord, reasons in my application as to why I could not file these documents at the earlier stage. What precluded me, my lord, the reasons are, my lord, a lengthy affidavit has been filed. My respectful submission, my lord. If the parties are allowed to undergo, my lord, trial with respect to these documents, my lord, the truth will certainly, my lord, emerge. If I am in a situation where, my lord, everything, my lord, is concocted or something as, my lord, alleged by the other side, the truth will certainly come out. Insofar as, my lord, the other part of counterclaim is concerned, the court has merely taken a view, my lord, that in the light of the so and so, this counterclaim is decreed, my lord, that certainly requires, my lord, reconsideration by the trial court. Because portion of, my lord, the appeal has to be necessarily remanded in the light of the material that is placed on record. My lord, if the matter, by allowing both the appeals, my lord, if it is remanded, my lord, the ends of justice would be served. And my